Ladies and gentlemen, we're going to call to order our first hearing of the evening. This is a continued hearing. It's the application of Michael DeCita at 14 Cantwell Road in Milton, Massachusetts. The application is dated April 29th, 2013, and we had our original hearing on May 29th, 2013. We continued the hearing to this date in order to secure a Board of Appeals decision in a previous case that may be relevant to Mr. DeCita's application, as well as to allow Mr. DeCita to read, review, and respond to some of the comments that we've received. Just for the sake of the audience, Mr. DeCita owns a property at 14 Cantwell Road in Milton, and the property is located in a Residence C district. And Mr. DeCita is proposing to build a 4-foot by 38-foot extension at the rear of the existing family residence at 14 Cantwell. And the deck extension is to be set back 20 feet 6 inches from the rear property line, when Section 61 of the bylaw requires a minimum rear yard setback of 25 feet 5 inches from the rear property line. So my name is John Leonard. I'm Chairman of the Board of Appeals. I'll be presiding at this particular hearing. With me tonight, immediately to my left, is Board Member Jeffrey Mullen, and to my right is Board Member Emmanuel Alves. The rules of the board are going to be such, just as the last hearing, we'll hear from Mr. DeCita. We'll hear from any person present who has questions of Mr. DeCita. Then we'll hear from any interested person who wishes to speak either in favor or in opposition to Mr. DeCita's application for variance. We're tape recording the proceedings this evening as always, so that we'd ask that before anyone speaks, tell us your name and address and speak up nice and clear and loud, so we'll have a rather accurate recording if we have to revert to the recording in order to prepare a decision in this case. So without further ado, Mr. DeCita, welcome back. Why don't you come on up here and make yourself comfortable. If you want somebody to accompany you, you certainly can. Do you want to come up? Sure. Why don't you just introduce yourself?
Okay. My name is Terry DeCita. I'm Mike DeCita's wife, and I also reside at 14 Cantwell.
Great. Thank you very much. Welcome to the Board of Appeals. Mr. DeCita, why don't we hear from you, sir?
Thank you very much, Mr. Chairman. I should also note that my daughter, Emily DeCita, is here with us today as well.
Hi, Emily. Do you want to come up here if you can? Why don't you come up with Mother and Dad? You'll enjoy it. We don't bite.
She just asked me if she has to, and I...
No, you don't.
If she's okay back there with the board, I'm okay with her back there.
That's fine.
Okay, thank you very much. Mr. Chairman, before we begin, I just had a procedural question. It was my understanding from the close of the last hearing that there would be, excuse me, that today's proceedings would be limited in scope, that this would not be extensive evidentiary presentation beyond that the board had received the evidence that it was intending to decide this matter upon. I'm certainly prepared to offer evidence or and make arguments in support of our application, but I wasn't sure where we were procedurally with this matter.
Okay, well, procedurally, we thought we basically heard the evidence at the last hearing. At least you made a full and complete presentation. I think the board continued the hearing to review the previous Board of Appeals decision on the original variance, which allowed the bungalow. This was a variance granted before you owned the property, which allowed the bungalow residence to be converted into a smaller garrison colonial type structure such as this. But that having been said, this is a public hearing. The evidence has not been closed. If you want to present additional evidence, we're delighted to hear from you. And likewise, if there are people present who want to be heard on the application, we're delighted to do that as well.
Okay, thank you for clarifying. I think I'd like to begin by responding to the arguments made in Mr. and Mrs. Fournier's letter, which I hadn't received until the hearing in May. I won't.
And that's an extensive letter. It wasn't a two-sentence letter. It was a couple of pages, and it was rather detailed.
Despite the detail, though, I don't want to spend an inordinate amount of time on it. I think, to be short, the letter simply does not accurately describe or depict the project that we are seeking the board's approval to undertake. Mr. and Mrs. Fournier assert that we are, if the board approved this application, there would be a topographical barrier between the properties that would be destroyed. In fact, there's no topographical barrier that would be affected by this proposal at all. What we are seeking the board's approval to do is to build an extension of our deck that would be, in fact, 6 inches below the level that our yard was at when we moved into the home. It is also 6 inches below the same level of the, excuse me, of the land, of the area confined by the retaining wall that we have built. The proposal that we're seeking the board's approval for has absolutely no impact on the hill, the ledge, or any other aspect of the property. It's simply an extension of the deck. It is, to be sure, 6 inches higher than the existing deck, but as I mentioned already, it's 6 inches below the level of the land in our backyard. The Fourniers assert that the deck addition will be 3 feet higher. That is simply not true. Again, it would be 6 inches lower than the existing yard. I sent Mr. and Mrs. Fournier a letter last month explaining the proposal and offering to meet with them to address any questions or concerns that they might have, telling them that I'd be happy to invite them over so that I could address any of their concerns. I did not hear back from them. I understand that the board has an obligation to consider reasonable objections to any proposal that's before it, but the emphasis here is on reasonable objections. If the Fournier's objections are based on mischaracterizations, misrepresentations of our proposal, those objections are simply unreasonable and don't warrant the board's consideration. I also want to address the privacy considerations. Our yard, the flat part of our yard is 7 feet below the level of the Fournier's yard. The deck that we're proposing to build, again, is 6 inches below that. We simply have no line of sight into the Fournier's yard, even if you disregard the 7-foot, 6-inch high fence that they built on the back of their property line. I also want to respond to a concern about, or address the issue of access to our yard. I'm not asserting tonight that we have no access to the yard, and I don't believe I asserted that in May. What I am saying, though, is that the access to our yard is fairly limited, and it's inconvenient. In order for us to use our backyard, we need to walk away from it, for starters, down 5 steps, double back, either around the south side of the house or alongside the deck on the north side of the house, and then climb up 6 steps. I don't know of any other properties in Milton or elsewhere. I'm sure there are some, but I don't know of any where you need to walk away from your backyard in order to get to it, where you need to walk down and then up in order to get to your yard. I'm 51 years old, and I'm in reasonably good shape. It's not a tremendous inconvenience for me to, it's not something I can manage physically. My father, however, is 80 years old. My wife's mother is 72, and she's visiting next week. When either of them visit, we simply can't use the yard because of the difficulty we have in accessing it. As I indicated last at the original hearing, the elevation of the yard, and whether you're looking at it before or after the construction of the retaining wall, and the steepness and the rockiness of the slope that makes up most of it means that a literal enforcement of the code's provisions and setback requirements results in a hardship to us, and that our yard is not very usable in its current condition. Granting a variance will not result in any detriment to the public. As far as I can tell, our pair of houses, the Fournier's house and our house, are the only one of its kind on the Waldo, Cantwell line of houses. There will be no avalanche or floodgates opened as a result of any decision that the board makes with respect to this proposal. And again, as I asserted in our letter to the Fourniers, and I stated last time, I'm open to any reasonable modification that others or the board itself believes would be warranted, to make this a more suitable proposal. But barring that, I would ask the board to grant a variance to permit us to build what I believe is a modest extension of our existing deck behind our house. Thank you.
Great. No, thank you, Mr. DeCida. Let me see if my colleagues have any questions of you. Mr. Jeffrey Mullen, do you have any questions of Mr. DeCida?
Do you have any current photos?
Any current photos?
Yeah.
Nothing beyond the photos that I submitted in May.
So,
But those were current those were photos taken about the time of the submission.
so what is the full extent of the work that you want to do? You're going to extend the deck. You'd like to extend the deck, and then what about the treatment of the banking?
What, I'm sorry?
Banking.
The treatment of the banking.
What's going to happen? How is the yard? So the yard is still significantly sloped, so you'd
Yes.
be accessing a yard that's significantly sloped. Do you have any air? And you've flattened out one section of the yard, I think, closest to the driveway, right?
That's correct.
Do you have other plans to change the topography?
Absolutely none. As my wife will attest, I have spent much of this summer and the last summer planting bugleweed, which is a creeping ground cover to control erosion. My daughter will probably attest to this too. I've spent hours and hours and hours planting in the backyard to control erosion, and for aesthetic reasons, we planted a row of arborvitae along the back lot line, again, also to control erosion and for privacy purposes. We've planted some, I don't know if they're apparent in any of the pictures, no, I don't see them in here. In the southwest corner of the yard, I've planted probably 40 lilies, 3 azaleas. I have absolutely no plans to tear any of this out. It's just not, I've nothing else planned. So the short answer is no. I'm sorry it took me so long to answer your question.
And when you extend the deck, it's just going to be an extension, not a new deck? So how is that going to, basically my question is, how is it going to appear? Is it going to appear all as one deck? Is it
Yes.
the lattice underneath it? And
Yes, that's correct. And one of the things we need to do regardless is replace the railings. The railings are, there's some water damage to the railings. Couple of I think 1 or 2 of the posts was knocked out when one of the trees that had been there before, part of it fell on that. So our plan is to make the extension of the deck part and parcel of the existing deck, make it aesthetically appear to be like single construction, like as if it were constructed at the same time. Yeah, we will probably need to replace the existing decking.
the board will, and is assuming that it will appear as if it were originally constructed that way.
Absolutely.
It won't be 2 decks.
Absolutely, and from our standpoint, we want the deck to look nice. We want it to be aesthetically pleasing, and the way to do that is to make it look like a single construction. The railings will be integrated. The lattice will be, the lattice configuration would be the same. So we would do everything we can to make it look the same.
I apologize if you addressed this in the first hearing, but how is it going to work with the stairs that currently go into the yard off of the deck? You may be able off the deck onto the stairs into the yard?
So the plan would be to connect the 2 retaining walls. and to fill the area that's currently the stairwell.
No more stairs.
No, essentially, so that all you would need to do would be to take the 1-2 steps up from the deck extension, which would abut the retaining wall.
So it will appear as if there were never stairs there, and
That's
it'd be
correct.
filled in, would be part of the
That's-
yard.
That's correct. There's a
I see.
concrete wall, there's concrete walls that surround the stairwell. Those would be jackhammered and removed, and then there would be fill there, so it would look like
I
one
see.
single flat surface.
Okay.
Just to follow up on that point, because I had a similar question. So the gap that exists currently between the rear of your house and the wall that goes onto the flat space will be covered by the new deck in its entirety?
What's essentially a gangway behind the deck, yeah, the flat part,
No, I'm talking the whole side, back side of the house.
that's correct. That's
So-
what we've proposed, yes.
Right. And it will be the existing deck, one step 6 inches to the new deck, and then another 6 inches to the existing flat part of the yard?
That's correct.
Gotcha.
Oh.
Do you have another question, Mr. Milton? Are you all set?
I hadn't appreciated that until.
Yielded my time, obviously.
Okay, I don't have any further questions. If you don't have anything else to add, Mr. DeCita, why don't you stay right there, please? And let's see if does anybody out there have any questions regarding Mr. DeCita's application for variance? Okay, so, yes, sir, please.
George and Barbara Fournier.
Oh, good. Do you want to come up here, Mr. Fournier, so you can be heard? I know you may not want to, but unfortunately, in TV land, you've got to be picked up by the microphone. So why don't you grab a seat there? Mrs. Fournier, do you want to come up here as well? Okay. Why don't you tell
For
us
the
your name
record.
and address, sir?
George Fournier, 34 Waldo Road, Milton.
And I'm Barbara Fournier, spouse.
Good. Welcome to the Board of Appeals.
Hi.
Thank you.
Thank you for your previous letter.
Thank you. And thank you for your consideration in having this follow-up visit and giving us the opportunity to address you in person. We were away on vacation that had been scheduled many, many months before the notice of the May meeting, so we were unable to attend that. I also appreciate you raising the issues of prior variances granted to that property. When we moved to Waldo Road in 1976, the view in that direction of our backyard was unencumbered. We had sight lines to the sky. The bungalow home there, the peak of that roof was below the existing fence that borders that section of the yard.
And there were a lot of trees.
When that owner died, a variance was applied for in 2001 to build a second story. We did not oppose that. In fact, we expressed our feelings that it could only better the neighborhood to have a more substantial house there. However, we regretted that because it turns out that we were misled. We felt we were misled with regard to the height of that house.
And that's by the previous applicant
By the
and not by
by
Mr.
the
DeCita?
2001 applicant, not the current owner. However, in 2010, when we came home one day, early in the day, to find a crew cutting down the trees in that backyard, several of which were actually on our property, we obviously became quite upset, and we're even more upset to be told that this was being done because the trees were diseased. Well, pictures that we submitted, or were submitted on our behalf by Mr. Wahlberg at the last meeting, clearly show one of those surviving trees, which has been looked at by an arborist and found to be quite healthy. And it's our opinion that the trees that were cut down were not done so for reasons of disease, but rather in anticipation of being granted a variance to put this monstrous 20 by 18-foot deck on,
Mr. Chairman?
which would,
No, no,
excuse me,
Mr.
I didn't
DeSena,
interrupt
please.
your
Let,
procedure.
well, we understand your concern. Let Mr. Fournier talk.
Okay.
Well, we understand everyone. These things can get personal. We don't want that to happen,
And unfortunately, there's been very poor communication,
that's
for
usually
a
the
number
case.
of
But
years.
don't
yeah.
worry. We
Okay.
understand exaggerations, and we take
Okay.
the evidence
So,
as it is. Go ahead.
At that time, I expressed my concerns about erosion, because these trees had extensive root systems. There were probably 9 of them, sugar maples, and they were what was holding up this very steep wall separating our two properties.
To whom did you express
To
those
the
concerns?
homeowner.
To the homeowner. Okay, great.
Okay? Over the course of the next 12 or 15 months, we had some heavy rains. We experienced erosion. The fence that was there was washed out. And
And that was your fence?
my fence, and it cost me over $4,000 to not only restore the fence, but also, on the advice of the people I consulted, to build my own retaining wall at the top. Mr. DeCita followed up with some planting of shrubs. They were approximately 6 inches high. And at the age of then 68, 69, I didn't anticipate seeing them in my lifetime. They certainly haven't helped with retaining erosion over there yet. That application was denied, I'm happy to say, for that deck. However, again, prior to a discussion with me, prior to an application to you, the homeowner went out and built a stone wall, 18.5 feet by 13 feet, almost 55 inches high. Then he backfilled it. So that basically what we have here is an earthen deck in a place where the wooden deck was denied. And tonight's application is to connect up the existing deck with that new earthen deck. Without any plans,
The earthen deck that was constructed did not need a permit or a variance. He could do that as a matter of right.
Correct.
Is that fair?
I believe so. I don't know the statutes in
All
that
right.
regard, but again, no discussions preceded it, no explanations were given. Instead, we're asked to agree to a deck 4 feet by 38 feet long. A rather unusual configuration. Difficult to figure out what is the game plan here. And in fact, if you look at the blueprint that was submitted, it provides no detail about the height of this deck, about how it's going to be attached to the existing deck, how it's going to be affixed to the new wall, as well as the old wall. And it just continues to create this appearance, at least, of deception, or at least not complete honesty as to where the plan is going. We have great reservations because of that, and continue to be unwilling to support it. With regard to some of the contentions made tonight, that our letter was filled with inaccuracies, I take umbrage at that. The difficulty of using the backyard is indisputable. That backyard has been like that for 60 years. It was never a usable backyard, and that was probably reflected in the value of the total property. The deck that is on the house is on the side of the house, not in the backyard. The slope, which was at approximately 45 degrees and ran down from the edge of my property line right to the top of his driveway. much of that has been eliminated at this point by the wall and the backfill. There's probably 20 yards of backfill in there now. But I think the purpose of the setback statutes were to afford Milton residents a degree of privacy. Not just auditory and visual, but aesthetic as well. And for the spirit of this statute to be subverted by a functional end runaround is disturbing to me.
So I guess basically, I guess we had over a 20-foot setback originally, and that's now down to under 6 feet. And if you take our fence away, which is our fence, and you look at what that yard looks like now, I think you would agree that you would not want to have that yard adjacent to yours. I mean, their living space is coming up right into our space in a way that topographically was not possible before.
Is it fair to say that if I'm standing at your residence or in your backyard, you would not be able to see the proposed deck?
Probably from our second floor you could, from our first floor you could not, but you could if our fence was taken away.
But you'd have to do that at your fence.
Well,
Mr.
there's-
DeCita
there's-
can't take
right.
down
Well,
your
under
fence.
under the circumstances, there's no assurance that this fence is going to survive the erosive properties that have been generated by the removal of these trees. These trees were mature maple, they were mature sugar maples. They were 40, 50 years old. The root system was extensive. Once that was gone, that wall began eroding almost immediately.
And I do feel badly that, that we can't be better neighbors and have talked this through, but we just feel like every time we've started to talk, we haven't been informed on what step 1, step 2, step 3, and then every time a new step is coming forward. So we got the letter July 31st, and we've been away out of town, so there wasn't a lot of time for us to feel comfortable doing this. And I'm sorry it's come to that. We've never had trouble with neighbors before, and I hope we never do again.
Okay, well, thank you. The remarks are well put, and I think nobody takes this in a personal sense.
Not
It's
personal.
just,
No, not at all.
let me see if my colleagues have any questions of you. Mr. Mullen, do you have any questions? I don't think so. Mr. Al, do you have any questions of the Forniers?
Just one, just make sure I understand this correctly. So the living space that I think I heard you say is getting closer to your property line is that flattened wall, elevated space. That's there currently. Whether or not this relief is granted, they can put picnic tables, they can do whatever they want in that space, so.
And we have
Is-
no right over that, is that
Right.
true?
I guess that's what I'm asking, that nothing's been done to that flat, maybe it's a question for Mr. DeCita. The flattened space above the stone wall, that's there.
That's correct.
I got you. Okay. I just
I
want,
would like to know what you're gonna do with it.
Well, that was going to be my question. You beat me to it. Do you have any idea what you're going to do with it?
Am I allowed to speak at this point, Mr. Chairman?
You sure are.
Okay,
We're
thank you.
delighted to hear from you.
Great, thank you. Our plan is quite simply to be able to come out of the kitchen, take a left, beyond that flat space. We have a table and chairs that we would like to put there. And, to have a meal, to enjoy our backyard. It's not a big space, but we do have a very busy street with some wonderful young children, about 23 of them playing in the street, because no one has a backyard. We would like a little privacy, and I know that the Fourniers, pretty much every summer, I can hear them enjoying their yard, and I would like to have that opportunity as well, to maybe have, a meal or, some kind of social gathering, and I envy them that they have that space and that they use it in the summer, and that's great. And really, I don't feel like they would see us. The fence is so high and this flat area is so low. We just want to be able to come off there and to, like I said, take a quick left instead of to the right and down the stairs and all around and up the stairs. I could bring the food out from the kitchen, we could have a little meal, and honestly, that is our plan. That is our goal.
Do you know whether you'd have to put up some type of safety fencing around that area in order to utilize it for those purposes?
I don't believe,
For children and other people, it looks like there may be reasonable fall-off there.
There is a drop-off there, and if the board thought that that was necessary for us to do that, or if the inspection service.
It's a building commissioner issue,
Yeah,
not,
if
not to
if
Okay.
the commissioner thought that that was warranted, we would certainly do that. I think, at this point, maybe some shrubs or something that would serve at both the purpose of improving the aesthetics and also provide some protection. Obviously, if somebody wants to run through an azalea bush, they can, but that would be.
We won't encourage that.
we wanna- yeah,
Okay.
so.
good. Thank you. Mr. Mullin, do you have
Thank
any
you.
questions? Mr. Alves?
No.
Is there anybody else out there? You can stay here if you'd like, or you can move back to the audience, however you prefer to do it. Thank you for coming tonight.
Thank you for giving us the opportunity.
Is there anybody out there this evening who wishes to be heard on this application? Let's say heard in favor of Mr. DeCita's application. So the record's going to indicate there's no such person present. Is there anyone present this evening who wishes to speak in opposition to Mr. DeCita's variance application? Okay, so the record indicates there's no such person present, so unless you have anything else to add?
I just want to underscore one thing that Mr.
Sure.
Fournier said, and that was the difficulty of using the backyard is indisputable. Mr. Fournier himself has acknowledged that our yard is not actually, I don't even need to say anything more than that. The difficulty of using the yard is indisputable. I think Mr. Fournier's statements, a couple of the statements were incorrect about us cutting down trees that were on their property. There was one tree that was beyond their fence that I believed was in part of our property that I was going to cut down, thinking that it was ours, but I did not. So,
Trees that get to be very personal things when
understand
you're
that.
dealing with
I understand
residences.
that.
But regrettably, I don't see preservation of trees in the zoning bylaw within the jurisdiction of this board.
And-
But it's an understandable comment.
And my wife will attest that I am a environmental nut. I mean, I'm very concerned about the environment. I did not cut down the trees lightly. I was aware of the benefits of having trees, but I was also aware of the risks of trees falling on our
Which has happened.
house, or parts of trees falling on our house, or neighbors, or children. Didn't want that to happen, so.
Yeah, I think most people, at least in my section of town, when they hear saws and trees going down, it causes immense concern. And usually it's considered good form, if not being a good neighbor, to talk to your neighbors and assure them that their trees aren't coming down and to show them what you're doing.
I understand that now, and in retrospect, I should have gone to the Fourniers before beginning that work. I wasn't aware that that was the tree culture in Milton, and I apologize to them for not having done so.
And we're not the social police either.
I understand
but it
that,
just-
I understand that.
It tends to soothe tensions. Okay, so if there's nobody else who wishes to be heard, we're going to close the evidence in this application, and we're going to, under the open meeting law, as you probably know, we're obliged to discuss the application tonight and to vote on it, and we intend to do that here and now. So, Mr. Jeffrey Mullen, do you want to be heard?
Well, this is an interesting case. This is the case that I remembered from 2001, right? So, and I remember the hearing to which you referred. This is also a little bit unusual in that I hear the complaints that are legitimately expressed by the abutters, but I don't know that they are closely aligned with the relief that's being sought. And I think that's a little bit unusual for a hearing that we've had. We could debate that, but I hear concerns about erosion, and I saw the photos, and I think those are legitimate. But I don't know that whether this board offers the relief or not, it's not going to change the situation on erosion, except to say that we may have some ability to affect it in the sense that we've had testimony that there is no intention to alter the appearance of the yard. So that's one point. The second point is I think the privacy concerns are overriding in the bylaw and zoning in general. But I think as applied with the topography, I'm not sure that that's a it's going to be, it's going to be made any worse by the relief, than it might already be, given the fact that as Emmanuel Alves indicated, you can already use the yard and access the yard and enjoy the yard in different ways, and perhaps not as well, but it's not as if the relief is all opening up new areas for access. And then the third is, I think the proposal is an improvement. And while I don't take lightly the concerns that were expressed by the abutter, and I think this board has a proud tradition of respecting those, I'd actually be in favor of granting the relief under these terms, with the testimony and with the conditions imposed and with the understanding of how the deck will be constructed as reflected in the testimony. So I'd be willing to have a debate and discuss it further with my colleagues, but those are my impressions from the 2 days, the 2 hearings that we've had.
Okay, Mr. Allen, please.
Thank you. I agree with Mr. Mullen. I think I'd be inclined to vote in favor for the application. I'll be brief. I do think that the applicant is aware of and has shown concern for the erosion issue that the Fourniers are raising. And if I guess I'd be willing to debate what sort of condition ought to be attached to the grant of the variance to ensure, in fact, that Mr. Fournier's wall, as he's indicated, doesn't come down with the next rainstorm. But I agree with everything Mr. Mullen said. I think the relief being sought here is slightly disjointed from the concerns I've heard from the Fourniers, which I think are real, and as Jeff also said, deserves, and the board has always taken them seriously. Again, in short, Mr. Chairman, I'd be inclined to vote in favor, but I would ask that and again, I don't have a specific condition in mind, but that if granted, the variance contain a condition that would require the decedents to look after the property so that the erosion issues don't get exacerbated.
Okay, well, I think like a lot of problems that start off with on the left foot rather than the right foot, that's what we're dealing with here. There's been a remarkable change in the nature of the structure, not due to you, that's interfered with the Fourniers' views and vistas. The property is a challenged property. You knew that going in. To protect their privacy, the Fourniers had to spend a lot of money on this particular fence, and there does seem to be a lack of communication, which just exacerbates issues. That having been said, the yard has profound topographic problems, and the Fourniers have, strike it, the decedents have a young family, and they want to try to utilize the yard in some way. The Fourniers are to the rear and protected by a huge fence. Admittedly, it's their fence, and they put it up to protect themselves from your lot. But they did it, and they did it wisely, and it's a substantial investment. And I don't think that how the proposed deck is affixed to the house, whether it's 4 feet or 5 feet or 3 feet or 1 foot, is really a material issue to the board. Those are building construction issues. My concern is would people standing on that deck be visible to the Fourniers, and whether you're seeking to put structures in your backyard which would allow people in your yard to look over the fence and essentially interfere with their privacy. And I don't see that to be true, and I think that's why I think Mr. Mullen is suggesting this kind of a disconnect between what you're seeking to construct and propose and how that's going to adversely affect neighbors. I think part of this also is due to the last proposal that you made, which you withdrew, in which Mr. Fournier intended to build a deck that encompassed his whole backyard. And so you were essentially decking over I said, I'm sorry, Mr. DeCita, thank you, Mr. Mullen, was trying to deck over the topographical problems in the backyard, and why that may be understandable from a practical standpoint. It was disastrous planning, and I think also that proposal may not have been fully discussed with the neighbors. So I think that it's incumbent on the board, as Mr. Mullen and Mr. Elf said, that the Fournier's privacy be protected, and that they shouldn't have to be putting up new fences every 2 or 3 years because of erosion. And I agree with my colleagues that there should be a condition in any variance that we grant that would require you to maintain the slope as it exists presently, and to some way plant or protect that slope from further erosion. We have photographs of the slope, it's part of our records. We have photographs as to what it looks like now. And I think that's a responsibility and a duty that we should impose on you here. And the Fourniers shouldn't have to be building foundations for their fence or a new fence because of erosion issues, which they contend are caused by your taking down trees in a overly exuberant manner, let's put it like that. And I think that may be the beginning of a series of constructive conferences that you can have with the Fourniers to show them that there's no erosion taking place, and in fact you're maybe planting it even in a more sophisticated manner. We're not landscape architects. We're having too much testimony about landscape architecture these days and before the board. But any good nursery can be of assistance to you as to what to plant and how to plant it and what the slope should be. So with that as a condition, I think I could be convinced to allow the variance. I don't think it's a severe imposition on the Fourniers. It's not necessarily a de minimis variance, because you're not asking for a few inches here, but considering what I look upon as the disastrous consequences of this backyard, extending ourselves to make it more usable to a family, if there's no serious adverse consequences on somebody else, I'd be willing to exercise my discretion in that regard. So, do you want to put this to a vote? Do you have some, Mr. Mullen, please?
What I hear, I hear 3 conditions, actually. I hear an obligation on the part of the applicant to construct the deck as proposed at this hearing and at the prior hearing, which to me means the uniformity and the appearance of the deck, and I have your incentive to make it sightly, but I think that's important to the neighborhood. The second is to maintain the slope in a manner that is reasonably or similar to as exists today, and the third is to take steps to prevent further erosion. I think the third one is a little bit hard to really understand what that means, and I suppose Justice Potter Stewart would say he knows it when he sees it, but you would really need to understand that a little bit more. But I actually think that goes to the heart of this hearing, and it's really about the principal objection that the Fourniers have expressed, which I think we all think is reasonable. So with the understanding that it is the third condition that I see the building inspector has arrived, so he's going to be charged with enforcing it as the years go on, and he's certainly able to do that with all the confidence in the world in him. Then as long as we understand it as those 3 things that we're really asking for, I think we should put it to a vote.
Well, look, I agree with your last comment, Mr. Mullen, in the sense that many times we deal with zoning distances, relief, height, and things like that. It's very difficult for us to deal with architectural issues, and we don't, and with issues of erosion. We're not land planners, and we don't pretend to be, but fortunately, we delegate that type of discretion to Mr. Prondak, our building inspector, who has done this for years. And if there is an issue on any of these conditions, Mr. Prondak can come to us and suggest that it needs further improvement. The Fourniers have the perfect right to come here and think and suggest to us that the erosion control program isn't working and needs to be improved, and we'll certainly do that. It's my hope that when if the variance is awarded and goes forward and you construct the deck, that maybe having the Fourniers over to look at the property and to have some coffee or whatever would be a nice way to keep everything in check. So all of those in favor of granting the variance with the conditions as outlined by Mr. Mullen, say aye.
Aye.
Aye. Mr. Mullen says aye.
Aye.
So congratulations with the variance, but we really hope that some communication gets involved here, and then everyone can enjoy their backyards, their fences, their walls, and enjoy two properties which really do have topographical issues that need to be dealt with in a common sense way. So
Thank you very much.
congratulations on your variance.
Members of the board.
Let me see.
Sure, one.
You take it, Chuck?
I'll take it, man. I'm happy to, whatever you like.
I'm gonna be out for the next couple of weeks.
Okay. Where you going? Little vacation?
Yeah, just down the Cape, not going anywhere, just recharging,
Good for you.
yeah.
I think we're still on television.
That's it.
It's not gonna be your usual banter.
Thank you.
We'll see you later.
Have a nice vacation.
Thank
Nice to see you.
See you, fellas. All right, Manny. Great to see you. You too. Enjoy your vacation. Hey, Brian. How are you? Time to see you. Still going to the 10 o'clock?
No, actually, I go to see. Sorry to be leaving you.
Johnny King, how are you? Nice to see you.
I just saw it. Summer gun.
Hey, man.
Ah,
Okay.
working hard, I guess is the way to put it.
Maybe you're looking forward to the summer ending, eh? Hang in there.
How have you been?
Pretty good, pretty good. Good evening.
Joe, grab a seat. How are you? Good, nice to see you. You want to stay back there, or do you want to come up here? You want to stay back there, or do you want to come up here?
Jenny, how are you? Yeah. Good, thanks.
Yeah, we'll just see how that goes. Okay, fine.
Do we have much more sophisticated equipment than we probably thought?
I don't know, I thought, told the kids I thought it was a rock concert.
We don't have to really.
No, you don't, you just have to speak into the
Right.
microphone.
Yes. On that, go ahead. Actually, I thought there'd be more people here tonight.
Yeah, I did too. That's all right.
Discount on car insurance if you get able.
It's all right. The last one. That's all right, that's fine. That's fine.
No cookies?
Didn't work last time.
I wonder why. Okay, is everyone all set?
Yes.
Okay, great. So we're going to call to order our second hearing of the evening. This is a continued hearing. It's on the application of Philip Johanning and John Rowe, who live on Hillside Street in Milton.
23 23 Parkwood.
Okay. Okay, this is the Hillside Street, this is the nursery. Okay, I thought that happened to be the address. They're on Parkwood, Mr. Ruteki's former house. And this hearing originally was commenced on May 21st, 2013, and it was continued by agreement to this evening. Let me take care of some preliminaries first. At the previous hearing, we had a court reporter present, and we have one present again this evening. It's Tony Beckwith of Federal. Okay, the card doesn't say Federal, but Ms. Beckwith tells us that Federal Reporters. And so we had our previous reporter taking the official record of the proceedings, so I presume we're going to be doing the same thing here, Mr. Dunn.
Yes.
And Ms. Beckwith needs to be sworn. Our last reporter was sworn, but she's not here tonight. So, Ms. Beckwith, do you solemnly swear to honestly and faithfully take the transcription of the record at this hearing? Good. Thank you very much, and welcome to the Board of Appeals. Let me just mention a couple of preliminary things. We're dealing with a court reporter tonight, so the hearing tends to be a little more formal, and it's very important that we have a clear and accurate record of the proceeding, so that we'd ask that people be very careful to not only tell us your name and address before you speak, but that no two people be speaking at the same time, don't talk over each other. We'd ask people not to mumble or make facial gestures which don't appear in the record. Don't nod your head, yes or no. Express yourself verbally. Express yourself after you've been recognized by the chair. And I'd certainly encourage Ms. Beckwith that if at any time there's some colloquy taking place, as sometimes naturally does, that she can't pick up because people are talking too fast, they're reciting numbers too fast, or they're bantering back and forth, that you just stop us in our tracks, Ms. Beckwith, and we'll be sure that you are able to pick that up and we have an accurate record of the proceeding. Is that all right with you? So don't be bashful. And likewise, this may be a short hearing, but I tend to doubt it. So if at any time during this continued hearing, you need a break to rest your fingers, to take a stretch, be sure to let us know, and we're delighted to do that. So with that having been said, let me just do some introductions for the record so we'll know who's here. My name is John Leonard. I'm chairman of the board, and all of these members were present at the last hearing. To my immediate right is board member Virginia Donahue King, and to my immediate left is board member Brian Hurley. The rules of the board are going to be the same as the last hearing. We'll hear from the applicant and hear from the nursery and people who have questions of either parties and people who want to be heard regarding this application. In the interim, and also Ms. Beckwith is going to prepare a transcript like she did in the first hearing. We thank Mr. Dunn for providing us with a copy of that transcript. We don't have a lot of funds here at the Board of Appeals to order transcript, and I assume you're going to provide us with another copy of Ms. Beckwith's.
Yes.
Great. Thank you. So what happened in the few months preceding, subsequent to the hearing, is we did receive some supplemental material from Mr. Dunn based on the evidence at the last hearing, and we received a supplementary memorandum of law from Mr. DeLuna on behalf of the nursery. We also received, within the last day and a half, 65 emails, an avalanche of emails, 64 of which are in support of the application, and one of which is opposed to the application. So we encourage people to file letters and to let us know your views on all of the issues before the board, but we weren't expecting such an over-exuberance of response. Needless to say, I'm not going to take the time or clutter the record by reading these materials. We've looked through them. They appear to be reciting fairly familiar things that have come up at the hearing, but they will be taken in evidence and given the weight that we think they're entitled to if either Mr. DeLuna or Mr. Dunn would like copies of these for your own personal files. I'll have Mrs. Fitzgerald after the hearing make a copy and send it out to you by mail. We won't keep Mrs. Fitzgerald here till 11 o'clock making copies, but I'm not sure there's anything new in here. I didn't see anything new, but we encourage that type of response, and we have received it. So we also have received, if I can keep my papers in order, an email from Maggie Oldfield at the Thayer Nursery inviting the board to take a view of the premises. And we also received that Ms. Oldfield's request for a view of the property is dated August 9th. That was followed up with an August 13th, 2013 request for a site visit by Mr. DeLuna, Attorney DeLuna, on behalf of the nursery. And then we also received a response from Matthew Dunn, the attorney for the petition is here, dated August 14th, indicating his client's willingness to have a view and set forth various conditions relating to the view, which we can perhaps discuss at some point in time. So we have those on file, and I think that pretty much covers the preliminaries. Mr. DeLuna,
You
yes?
should have received an affidavit that was hand-delivered by Maggie Oldfield relating to the percentages
I-
of,
I did not receive that. I don't have it here, I haven't seen it. Mary, do you recall? To whom was it delivered, do you know?
Maggie?
I delivered it, Mary was out.
So to Mrs. Colligan? Mrs. Colligan was filling in. I'm sorry, it was Jay. It hasn't made its way to our attention. Do you have a copy of that, Mr. DeLuna, or? Because I think that was one of the questions that I had for you when we get into the substance of the hearing. Yeah, why don't you take a look and see if you see it in there. Mr. Dunn, did you receive a copy of that affidavit?
Affidavit of Margaret Oldfield,
Yes.
dated August 9th.
I don't know, I've never seen it before.
Yes, that's, I apologize, I do not, and I don't know why I don't have a copy of it in my clip.
How long is the affidavit,
It's
Mr.?
one page,
2 pages.
Two-page?
2 pages.
So you can make a copy of mine if you'd like.
Yeah, I don't have a copy in my clip.
Okay. Well,
Prontak's
now,
gonna
while,
make a
while
copy.
that's being copied by Mr. Prondak, even though that's beyond his scope of responsibilities, let's deal with the applicants. And Mr. Dunn, do you want to be further heard on this enforcement action?
I would, and I appreciate the board having us back in this evening. We covered a lot of ground back on May 21st. As Mr. Chairman reiterated, there's been a lot of documentation submitted, both for and against this action. Our argument is spelled out and summarized in the original memorandum that was submitted, along with the exhibits that were presented back on May 21st. But I've been asked to reiterate a few points to the board. The first one being is that my clients, Mr. Rowe and Mr. Joenning, are not out on a vendetta. They're not attempting to be vindictive in any way. They're not trying to close down anybody's business. What we have at Thayer Nursery is a number of businesses that have simply outgrown the zoning district for which they're operating. And at this point, it's beginning to affect direct abutters to the property, of which my clients are two. I know this board has received a lot of correspondence in support of Thayer Nursery's activities on the property. I haven't seen the latest 65 emails that have arrived, but you know, I tend to suspect that none of them are from direct abutters who have to deal with the day-to-day operations of the unlawful activities that are being conducted at 270 Hillside Street on a daily basis. My clients also are not contesting the traditional use and understanding of what the property was allowed to operate as back pursuant to the 1967 permit issued by this board. And that is as a nursery. There's, that use is not contested. It's permitted under the special permit that was issued back in 1967. It's also permitted a portion of the property that there can be an argument that a portion of it could be used under the Dover Amendment. What we're contesting here is there's 3 activities that are simply not related. They're not incidental and not accessory to the permitted nursery business that's allowed to operate there, and to find that they're incidental or accessory to is really stretching the bounds of human reason here. As was presented to the board back on May 21st, there's a large-scale commercial off-site landscaping business that's being operated at 270 Hillside Street. There's a landscaping construction business that's being operated there. The materials, which none of the materials, at least back in May, were utilizing agriculture or shrubs or plants that were being cultivated on the property as part of the nursery business. And those the photographs depicting that were presented to the board. They're included in the package that I provided to this board back on May 21st, and I have large blown-ups here. They're not, the activities are not accessory, they're not incidental, they're not permitted under the zoning bylaws, either as by special permit or by right, and therefore they need a use variance, which their nursery has never obtained. They've never applied for. This argument is consistent with what this board found back in 2002. It ruled that the landscaping and construction business had essentially outgrown what was contemplated in the 1967 permit. That is the law of the land, as far as I'm aware. That has never been reversed. There's been no finding in the land court that has ever changed. And I'm not sure that the filing of the appeal contesting the validity of that changes this board's finding. I'm aware of a similar 2010 action that concerned some adjacent parcels that were leased by Thayer in order to attempt to implicate the Dover Amendment for agricultural purposes. We're not talking about, I mean, if we're talking about agricultural purposes, this is apples and oranges. Again, the construction business, the landscaping business are not agricultural. They're not accessory to agricultural. There's simply no way that ththese are allowed without the appropriate zoning relief from this board, which would be a use variance. But in that action, there's some language from Mr. Leonard in the written decision that actually strikes at the heart of our argument here. And if I could quote from the 2009 or 2010 decision of this board, it was actually May 12th of 2010. The chairman's reasoning was as such. It says, the chairman voted to affirm both determinations of the building commissioners because to do otherwise would be allow the purported statutory exemption to be manipulated and twisted into an agricultural protection for virtually any use of residential land as long as some agricultural activity was maintained on the property. The town zoning bylaw would thus be rendered meaningless. The legislature cannot have intended such a result when it created a protected status for agricultural purposes. What Thayer is attempting to argue before this board is that by undertaking some agricultural uses on this parcel, that the entire parcel is exempt from all zoning. And that is just, it stretches Massachusetts law and it stretches the human reason to extend it that far. So in closing, I'd ask this board to consider all the written materials that were before it. Both my memo of May 21st, the supplemental memo that was submitted on August 7th. I'd actually invite the board to take a site visit and to see the impact of these activities from my client's property and from their perspective, as opposed to someone who doesn't directly abut 270 Hillside Street. I mean, I think that it's very telling from the photographs, particularly this photograph here that was taken from my client's backyard, depicting sand, gravel, stone on the property. It's hard to imagine how this could be associated with a cultivation of agriculture on the property. It's simply a separate, standalone business that's being used, or the property's being used as a staging area for these activities. The photograph that's depicted here is also included in the package that was provided back on May 21st, and I don't want to reiterate information that's already been presented to the board, but I'd just like to indicate that this again shows non-agricultural activity being conducted off-site by Thayer Nursery that operates on the property as a landscaping company. It installs driveways and stone walls that, again, are not related to or incidental or accessory to the operation of the nursery business on the property. There's also a retail component to Thayer's business on the property that my clients contest. The items, the 1967 permit allows Thayer to sell, as amended, I believe, in 1987, allows Thayer to sell products that are raised on the property and items that are accessory there too. At this point, Thayer is selling garden furniture, lawn furniture, bird houses, things that are completely not related to the upkeep of any plant or vegetation that is brought onto the property. I mean, I'm not really even sure how much planting or shrubs or bushes are actually grown on the property. And I made this point in the previous hearing. A lot of this is brought in from off-site, and it's really a question of whether, in addition to all the arguments that I've already made, whether the importation of trees, shrubs, and vegetation that aren't grown naturally on the premises would even qualify as agricultural or horticulture under the Dover Amendment. And I think there's some case law that I cited, the Peabody decision, indicates that that may not be the case. So,
Can I ask you one question? I don't mean to interrupt you, but Mr. DeLuna's position there is that I think that Peabody was before amendments to the statute, and the statute contains a specific amendment that talks about if you nurture and you prune and maintain trees, bushes, shrubs that you acquire off premises but bring them on premises, and you feed them and you nurture them and you maintain them, that type of activity is protected by the Dover Amendment.
well, that may be Mr. DeLuna's reading of the statute. I'm not aware of any case law that's overturned the Peabody decision. If I'm incorrect, I'm sure Mr. DeLuna is going to point that out to me. But you know, that's really one aspect of it, and it's sort of it's tangential to the main argument here, because we're not contesting the activities that can arguably be related to the nursery. What we're contesting here, and I'll close with this, is the operation and use of 270 Hillside Street as a staging area for the commercial landscaping and construction business on the property. It uses a large amount of large vehicles. It uses products that emanate offensive odors onto my client's property. It's inconsistent with the residential character of the neighborhood. And again, there may be a lot of people that support Thayer Nursery, and my client doesn't oppose the business of Thayer Nursery. They've simply outgrown the location where they're currently operating. It's having an adverse effect on a direct abutter, and these zoning bylaws that have been enacted by this town are designed directly to protect homeowners from this exact situation. This board has already found that the activities have exceeded the levels that are permissible under the 1967 permit. All we're asking for is that the board be consistent with its prior decisions, that it enforce its own bylaws, and that it reverse respectfully Mr. Prondak's decision not to do that. And for that, I thank you for your time, and I just ask for your consideration.
Great. Let me ask you two questions, if I could, Mr. Dunn. Uh, We last heard this matter on May 21st, 2013, and one of the concerns of the board, and I think concerns of council, was that in 2001, I believe it's 2001, it could be 2002, the board entered a decision dealing with Thayer Nursery and this type of use, and my memory was that everyone appealed. Thayer Nursery appealed to the land court, and some abutters who had brought a petition also appealed to the land court. And the last record of that proceeding we had was that it's been 10 or 11 years and it still hasn't been resolved in the land court. And nobody at that time, and I'm not being critical of anyone, seemed to know where the case was, what judge had it, or what was planned, whether there was a schedule of activity in the case. And I was just wondering, out of curiosity, not to be questioning or critical, whether since that time we've learned anything, or you've learned anything more about the status of that long-standing appeal.
I have not learned anything new on that. I can only reiterate to this board that my clients were not parties to that action. They have an independent right to pursue this enforcement request that is in no way contingent upon the adjudication of that land court decision. They may have a right to intervene in that case if anybody can find it, and I don't know if that's the case. But they certainly have standalone rights here.
Oh, I don't think anybody's challenging their right to proceed in this manner. It's just that it would be helpful in the intervening 10 years if we had some guidance from the judiciary as to where we are.
Respectfully, there's been no decision from the judiciary. The only guidance that we have is from this board, from its 2002 decision, which expressly found that what we're complaining about now couldn't be done in 2002. I don't believe that Thayer Nursery has decreased the impermissible commercial activities that this board found offensive in 2002. In fact, I think that those activities have been expanded. Like I said, to be consistent with prior findings of this board would require a finding from my clients.
Let me just add, I'm going to come back to you, Mr. Dunn, but Mr. DeLuna, perhaps, do you have any additional helpful information as to what's happening in the 2002 appeal that's been pending in the land court?
No, I do not.
Okay, so we don't have any follow-up there. Then let me ask you this, Mr. Dunn, on the question of the view. All of the parties here seem to want the board to take a view. Okay. You've taken views, and I know Mr. DeLuna has many, many times, and I know you have as well. There are two issues with the view, in my view, without being cute. Number one is the timing of the view. The view, yes, or site inspection, I should say site inspection. One of the problems is and I'm not being critical in any way, but we had a hearing on May 21st, and we had 2 or 3 months. We could have taken a view if anyone wanted one, but everyone seems to be in agreement that you want to take a view. The difficulty posed by that is twofold. Number one, we have a date that everyone's agreed this case has to be decided by, and that's August 29th, okay? I have no time to take the view on the dates that you're suggesting, okay? And that's number one. The view on or before August 29th is not convenient, at least to me. And in early September, I have 2 cases, one in the land court that's not 10 years old, that's going to go forward because it's been scheduled, and secondly, a matter in the probate court, and that court takes forever as well. So if you want a view, I think, but I'll talk to my colleagues, obviously, we're delighted to accommodate you, but it's not going to be within the time frame you're looking for. Secondly, everyone knows that if you take a view is not an argument, and a view is not a chance for the lawyers or third parties to make statements or anything. You can point out objects, you can point out berm, you can point out crushed stone, but you can't get involved explaining what it is and why it's there, because you could have a court reporter at a view, but it's a very rare occurrence, particularly if you have a site that's, I believe, 8 acres, and the court reporter doesn't have one of these things hanging around their chest like they do in Washington, D.C. The court reporter would have to run around and keep putting her her little transcriber or whatever it is there down. It's very, very awkward. So let me ask you this. If the board does conduct a view, do you anticipate then coming back for another public hearing as to what the view showed? Or would you anticipate closing the evidence tonight, if that's in any way possible, taking a view for whatever assistance it is to the board, but not reopening the public hearing? Mr. Dunn, do you have any thoughts there?
And can you give me a moment?
Sure.
We need to wrap this up. It's gone on way too long, and I think that we are entitled to a decision. We tried to be generous and continue, but I think we need to wrap.
Okay, would you just to the record indicate which one of your clients was
Bill
speaking?
Johanning.
Thank you, Mr. Johanning. Did you get Mr. Johanning's comments? Thank you. Mr. Dunn? Are you going to be guided by your client's?
I am guided by my client in this.
Okay, Mr. DeLuna, do you want to be heard on the issue of the view?
Yes. Two things. I'm not quite sure the relevancy of a view from the petitioner's property where this is an appeal of the building commissioner's decision. So I'm not sure the relevancy of viewing from that side. Having said that, the Thayer Nursery is open to the public. No member needs to be given a guided tour. It is what it is. They can, on their own, visit the site and form their own opinion from that, if they wish. The alternative to that is to keep the public hearing open to such time as a visit could occur and close the public hearing at the time of the visit. And in order to accommodate that, my client will allow the petitioners on the property for the site visit as well, which they are not required to do.
Let me suggest this. We've had several instances where we've had views in contested cases. Okay? And it's certainly true in the Superior Court that a view is somewhat of a formal proceeding. It's not an informal soiree around somebody's property when they don't know you're there or anything like that. We under the the open meeting law, we always publish notice of a view. We think it's part of the proceeding if people want to have it. And we have to give 48 hours notice with the town clerk's office before we can take a view. It's our policy here that if there's going to be a view, the view takes place with all 3 members present and with counsel for the parties present. The parties themselves can be present, and the public can be present if they want to walk around on the view and take a look at what's there. They're perfectly entitled to do that. So having an informal view that I drop down Sunday morning at 7 o'clock or 8 o'clock in the morning, I don't think it's good procedure, and I think it can be dangerous, because you never know what happens when any individual member of the board is there. There may be people who talk about the case. There may be customers who talk about the case. So if we have a view, it's going to be a formal part of the proceeding. And I have no problem, subject to listening to my colleagues here, if we extend all the deadlines so that a view can be accommodated. After the view is taken, that the council can decide whether you need to end the proceeding right after the view, or if you want to have a further public hearing on what the view showed. I'll talk to my colleagues about that if everyone wants to proceed in that manner. My personal view is that I like to be expansive in granting views if you want it, and I would think that it would be appropriate to view the petitioner's property as well. If property's going to be viewed, let's view it all, and then nobody feels short, cut out. And I think that would be an it's not an imposition. We're not traveling long distances, and so I think that if a view takes place, it'll be with all of the properties. It could be a little bit of an extensive view because you've got a lot of property there, Mr. Deloney, your client does. But hopefully it could be accomplished within in an hour and a half or so. Mr. Dunn, do you want to be heard?
I do. I think that Mr. Chairman, you pointed out, you made a good point. There's been approximately 3 months now in between our original hearing on May 21st and today's hearing. There was ample opportunity for the Oldfields to request a site visit before then that would accommodate the August 29th deadline for this board's decision, which I'd like to point out is actually an extension of what is statutorily required for a decision in these types of actions. Anyways, it was a accommodation by both me and Mr. DeLuna based on just the sheer amount of facts and evidence that this board needs to wade through. So based on the position of my client, I'd ask that this matter be resolved today or as soon as before August 29th, with or without a view.
Yeah, that's one of the problems I had with your letter, because you were suggesting a view on dates in August with a decision. You wanted the inspection to occur on August 26th, 27th, or 28th, and you wanted the decision on the 29th. And with all due respect, and I know you're not being cute, that's a severe imposition on the board. And that's an impossible thing to happen.
The letter that was provided was to indicate that we're not opposed to a view, provided that it could accommodate both my schedule, my client's schedule, and the deadlines that have been established in this proceeding.
Right.
So,
I'm not available on any of those dates. Okay. And if I write this decision, and I suppose I will, since I'm already quoted on the record, it's going to take me more than a day to write this decision if I'm going to do you any service. I could knock out a 1 or 2 page decision that wouldn't be worthy of the effort that you people have put into, both of you lawyers have put in, and your clients have put into this application. Let me see if my board members have any comments on the issue of a view. Mr. Hurley, do you have any comments on the view issue?
I have just 2 comments. First, it seems to me that the view is almost foreclosed by the schedule.
I'm sorry.
It's foreclosed by the schedule. If you're not going to extend the August 29th deadline, then there's no opportunity for us to take a view. So that really ends it, as far as I'm concerned. And second, just so the record's clear on this, although a view might be marginally helpful in this case, I think all of us are familiar with Day and Nursery. I haven't walked every nook and cranny of it, but I certainly have been there many times, and we have the benefit of the photographs. So I wouldn't feel it necessary in order to arrive at I think a fair and reasonable decision in the case. So A, we can't do it, and B, I don't think it's absolutely necessary that we do it.
Okay. Mrs. King, do you want to be heard?
Well, I have, in fact, looked at the property, and I don't feel necessary for me to go, and if my colleagues don't feel necessary, I see no reason to do it.
Okay. Mr. DeLuna, do you want to be heard on the issue of the view?
I think I've heard enough. Thank you very much.
Okay. So the answer is we will not take a view of the property. We'll rely on our general experience with their nursery and the photographs that are in evidence. Okay, Mr. Dunn, I think you've finished your presentation.
I have.
Mr. DeLuna, do you
Thank you very
want to
much.
be heard?
I did submit a memorandum with exhibits, and yes,
Yeah.
it was, I bait stamped it on the bottom so it would be easy to follow.
Sure, August 7th, 2013, is
I
that the one?
believe that's what it was. It's about 81 pages.
Okay. Great bedtime reading, Mr. Delona. It was fascinating reading.
Actually, I thought it was quite interesting.
Well, that's why you concentrate your practice in this area of the law.
First, I'd like you to turn or to reference page 67, or date stamp 67, of my memorandum. And we're not always this fortunate to have a memorandum going back to 1967. But what's important on page 67 is a description of the business being conducted on the site at that period of time. And it reads, it reads on page 66, the business consists of growing shrubs, flowers, vegetable plants on the premises and selling them to the public, conducting a landscaping business from the premises whereby the shrubs and plants raised in the premises are planted at distant location. The retail sale of fertilizers, pesticides, mulch on the property and pursuant to any amendment in the Milton zoning bylaws. Selling of Christmas trees, wreaths, and similar items. So that gives us a picture of what Thayer Nursery was in 1967. The memorandum also points out that when the Oldfelds purchased the property, all right, there was an existing agricultural business on the property. So what's happened since then? One of the things this board asked at its last hearing was whether or not the definition or the use of the word landscape or landscaping has evolved from the 1960s to the current time. So what I did is I went into, actually I picked up the phone and talked to our librarian, who did a search at social law and looked up some of the dictionaries going back, copyrighted in the 60s. And I asked her to focus on the word landscaping. And she did that from the 60s right to the present day. And the definition of landscaping, or the use of the word in our lexicon, has not changed. It continues to consist of the contouring of the property, all right, the planting of trees, shrubs, flowers, and it includes the installation of hardscape such as fountains and walkways. So in 1967, Thayer Nursery was conducting the exact same activities as the petitioners are complaining about today. The definition has not changed. What has changed is the Zoning Enabling Act and the Zoning Act. And it's very interesting as to how these changes have occurred and how the town has actually embraced, incorporated, in some cases violated, the statute. This is what I'm gonna.
Thank you.
Will I violate anything if I tape this on the wall?
I'll give you an indemnity so you can tape that on the wall.
this language is taking out of the building inspector's letter and opinion. It's in the first section, I may have paraphrased it. So let's take a look at 1968. 1968, we're operating under the old 48 Section 5. And I set the language of 48 Section 5 out in my memorandum. And 48 Section 5 does allow municipalities to require special permits or permits of some sort to regulate parcels of land to which agriculture is being conducted on. And Milton did just that. Right? The 48 Section 5 didn't have an acreage requirement. It was pretty open. So at that time, the nursery was developing. At that time, the neighborhood was developing. And at that time, there was tension between the nursery and the neighbors.
Shocking.
Absolutely. So they came before the board for a special permit. And the board issued a special permit. And in that special permit, they listened to the neighbors, and they listened to the needs of the nursery, and they read the statute. And they came out with a special permit with conditions. No parking on Hillside Street. There's no parking on Hillside Street today. Parking shall be on the premises. Parking occurs on the premises today. Trucks normally based on the premises shall be housed. A little bit of a problem. We'll visit that later. The premises shall be neat and presentable, which we believe it is. No unsightly piles of loam. Well, there's a little problem there is what's unsightly. Yeah, there's piles of loam. Right? I've been to farms where piles of loam have been completely full of pigweed and lamb's ear and things of that sort, completely seeded. Kind of a wild look.
But then they're not in the historic Scott's Woods district either.
Maybe
The
not
farm that you're
historic
referring to.
Yes, but I'm talking about the word, what is unsightly?
Whatever Mr. Prondeck says unsightly is, I agree with him.
Maybe. No manure piles. That's kind of interesting since they had horses at the time. No fertilizer that can have an odor to attract flies. No, all our fertilizer is packaged. And no heating plant shall be allowed to emit an odor or soot deposit perceptible to the neighborhood. Well, the days of the old coal-stoked greenhouses that I grew up in are gone. So we don't have to worry about that. Advertising, no advertising by floodlights, not allowed by the zoning bylaw or permit. There's been no argument that any of the advertising on the premises is illegal. And they did say we could have a 1 by 2 foot sign, flowers for sale, which may come out to be an unreasonable regulation in the future. The greenhouse can't be larger than 28 by 90, which it isn't. The merchandising activities shall remain at the present level. That's ambiguous and probably not valid. Lot A shall not be decreased. It's only been increased thus far. Business hours will be determined, and the late house. A late house is a facility that nurseries use so that they can keep nursery stock and not have it whipped by the wind so that you have winter freeze or it keeps shaded so the plants themselves don't burn. There is a late house there, has been there for years. That must comply with the laws, and obviously that was put up with an appropriate permit.
Put up with
An appropriate permit.
permit.
Now, in 1986, I'm sorry, 86, there was the acquisition of another piece of property. There was new questions raised, just as there are today, as to the activity being conducted on the property. So there was some amendments. They required shielding with evergreens to shield the residents on Parkwood Drive. That was done. They said that Lot 1B, the newly acquired lot, and this brings the lots, I think, up to 4.4 acres, all right, shall be used in conjunction with the Thayer Nursery. Now, also consider, this is 1986. This is about 11 years after the amendment of 40A Section 5. So this is now the zoning act, as opposed to the zoning enabling act from 1968. No more than 5 trucks. The trucks can be parked outdoors, but they have to be 65 feet from the northeasterly lot line. They allow the erection of a display room. And it allowed the special permit to go to members of the family, the Oldfield family, that would have been prohibited by the 1968. And it allowed the sale of firewood and garden tools. These are the activities that are actually being conducted today. There are 5 trucks parked on the site. Those 5 trucks used by Thayer Nursery are 65 feet from the appropriate lot line. So we have compliance with the 86. In 2001, there were further cries of noncompliance. This board heard it. I disagree with the interpretation that of this board's findings, but I will agree that this board did set certain requirements. And in November of 2012, we actually, the building inspector, the town manager, and town council, in an effort to settle the 2001-2002 land court case, did a site visit. And we found there is actually substantial compliance.
Oh, bless you.
2001 required mufflers to be installed on the Bobcats. Well, we made the inquiry. We found out if we put different mufflers on them, we null and voided the warranty. So what did the Oldfields do? They went out and they bought new Bobcats. So that condition has pretty much been taken care of. They don't run the Bobcats unattended any longer, and there have been no allegations that they have. The Bobcats don't idle more than 5 minutes at a time. There have been no allegations that they are. The Bobcats are used from 8 a.m. to 6 p.m. We would like to request a modification to allow us to start them running at 7. We haven't done that yet. The board recommended an improvement forward-only traffic pattern, with the exception of backing the Bobcats up to the building so they can move forward. That's the only time they're actually backed up. That primarily reduces the beep, beep, beep coming out of the Bobcat, which is required. Power washing only happen on weekdays. We've been in compliance with that. The compost pile and the dumpster were moved as requested. And the dust is controlled by periodic watering. You can notice the watering heads on top of the high poles. So in essence, we're pretty much in compliance with 2001. We revisited, we're visiting again, the same issues that were before you. All right, we believe we're in compliance. The building inspector has agreed that the site is in compliance. I did not see, he said he was satisfied with all the compliance, and if we can reach that, we can probably resolve the case. But for the purposes of defending his decision, I urge this board to do it. It was the correct decision. The old fields have grown, the statute has changed. They're in compliance with the statute, they're in compliance with the ordinance, and what they are actually doing is either permitted by an existing special permit or a matter of right pursuant to the statute.
Thank you, Mr. DeLuna. We
Thank you.
appreciate this. Any member of the board have any questions for either Mr. Dunn or Mr. DeLuna? Mrs. Kim?
I do, for Mr. DeLuna. Under the 1986 special permit, you have here shield of evergreens planted to shield residences on Parkwood Drive. That picture doesn't show them, so I wouldn't say that that was in compliance right now. Is there something I'm not seeing?
Depends on where you were with the camera, how close you were, but if you visited the site, you would see that there is a significant amount of evergreens that have been planted.
Well, it might not be enough is what I'm suggesting here. Also,
I also would suggest that was 1986, so we have 30 years since the plantings.
well, they should be bigger then. Merchandising activity from the 1968 permit. Did you say that it was supposed to be at the present level, meaning in 1968?
I would suggest that that condition is no longer applicable because what the statute has set forth is requirements. The bylaw or the permit cannot be contrary to a statute. So if you look at 48 Section 3, Paragraph 1 today, you'll notice that there, a farm stand, which this is considered, is allowed to sell non-products the 12 months out of the year, provided during the principal growing season. And Maggie's affidavit would back that up. 25% of the material that they sell is a product of the farm, meaning it's nourished, managed, and maintained by the nursery. So as long as their nursery fills that requirement, the rest of the season they can sell other materials, and they can sell 75% during their principal growing season of other merchandise.
I understand that, but I think what you said, at least I had written it down as something that you had said, was that the merchandising activity would be at the present level. But it's not, it is more.
And again, going back to 48 Section 3, that would constitute an unreasonable regulation imposed upon an agribusiness entity to say that that entity cannot grow beyond a 1968 merchandising level.
And what we haven't addressed here are things like stone piles, tiling, pavers, rock, walls. Because
Again,
because quite frankly, I think they weren't anticipated in all of these previous decisions. And so I'm wondering how we can talk about that being in compliance when in fact we have nothing out there to be compliant with, because that wasn't something that was anticipated, and it wasn't something that was given any, it's not given as any right of fact that you can in fact carry on that kind of activity there.
that activity or the sale of that sort of merchandise falls in the 75% category of the merchandise allowed pursuant to 48 Section 3.
So are you saying that this is something that should be in the display area rather than someplace else
The entire,
On-
the entire nursery is display area. People can come and they can look at the samples of rocks. Now, you also have to understand that when people order the rock, that rock may not necessarily be the rock that is displayed at the nursery. If they order a stone wall to be built, Thayer would order that material, and that material would be delivered to the off-site premises. In other words, if you were going to have a stone wall built on your property, those stones would not come
Of course,
from...
it's one less trip if you don't have to bring it to the
Exactly.
nursery. I understand that.
So all the merchandise that is used by Thayer Nursery, the installation, is not necessarily housed on Thayer Nursery property.
But we do have that sort of thing there.
Sure, and that's very specific. I mean, Mr. Oldfield was doing landscaping back in 1968, and landscaping included the installation of hardscape.
Well, I think that you might not have sold me on.
Mr. Hurley, do you have any questions of Mr. DeLuna or Mr. Dunn?
I had many at the last hearing. I was stunned to see how many I had when I read the transcript, but I have a couple. Just first, Mr. DeLuna, what language in Section 3 says that you can sell pavers on the property? I'm curious.
The language is, if you go back to the...
I have the statute in front of me. I'm just curious, what's the language in particular that says, that you would say allows somebody to sell pavers in conjunction with a horticulture or agricultural business? Because I can't see it.
I have a copy of the statute,
No,
Mr. DeLuna. Do you have one there?
It's in my memorandum.
Okay.
And if you take a look at, on page 6 of my memorandum, it goes, provided that during the months of June, July, August, and September of each year, or during the harvest season of each year of the primary crop raised on the land, or owner or leasee, 25% of such product for sale based on either growth, sales, dollars, or products volume have been produced by the owner or leasee of the land to which the facility is located. The owner or leasee of the land for which the facility is located. Now that says that 25% of the produce, the products, the nursery products, all right, has to be met. The other 75% can be other related matter. So the sale of the stone, the sale of the cobble is associated with the landscape and the use of the nursery products that people sell.
What about the language before the word provided, including those facilities for the sale of produce, wine, and dairy products?
Produce is not necessarily vegetables and lettuce.
But it's certainly not pavers.
No, it is the nursery product. That's the produce.
Well, we all know what wine is, but where are pavers and,
They're not. That's the other 75%. What they're saying is, I have to have 25% of nursery product there to be sold in that period of time. All right? The other 75% can be related. And the relation is, it's all tied into landscaping. The products sold, the trees, the grass, the turf, the flowers.
With all due respect, Mr. DeLuna, I don't think that's a reasonable construction of that statute, and I know you're an expert in the area. I don't read it that way. But it's really irrelevant to some extent, because you're relying on the special permit for purposes of tonight's discussion and not 48.3. And I take it in part you do that because the board in 2002 determined that the landscaping business was not protected under 48.3, and it treated it as a special permit, and rather than revoking the special permit, which it could have done, it simply imposed some additional conditions.
That is true. I don't agree with it, but
I
it
understand, but
it
that's-
works to my client's favor, and I'm gonna shut up.
I understand, but that's where we are today.
Yeah.
So here's my question. We're in the special permit world now. We're not in the 48 Section 3 world. And so we go back to 1967, and we have the language in front of us. And it authorized landscaping, and it didn't limit it, apparently, to products. In other words, as I read the 67 special permit, it didn't say you can only do landscaping if you're landscaping in connection with products that you sold to somebody. It can be independent of the products, if I read the 67 special
I
permit
would agree
correctly.
with that, yes.
I'm glad we agree on something at least tonight. So, but the question I have in my mind is this, and it comes from personal experience. It doesn't happen to be Thayer Nursery, it was somebody else. But, so I call up my landscaping company, and it has nothing to do with landscaping of my property, at least by my definition. And I say, I'd like to put in a new thing in my backyard, a new patio. I have a terrible old patio. Can you guys do that? And Rob Dick, to most landscaping companies now say, of course we can. And they come out and they rip out the old and they put in the new, and they don't sell me any product, and they don't mow the lawn, and they don't do any of that stuff. Is that within the purview of landscaping from the 1967 special permit, as you understand it?
Yes.
And is that because of all the definitions
Yes.
that you gave to us?
Yes.
So it may not have been within that purview as it was understood in 67, but you think landscaping, as that term was used then, has evolved to the point where it includes pavers. And by asking this question, I don't mean to suggest that I have formed an opinion on that. I'm just want to know your answer to that.
I would suggest back in the 60s, because pavers were not popular at that time, what would have been sold would be river rock or slate. Now, things have evolved, and landscapers don't necessarily use river rock or slate any longer, and they use the interlocking pavers. So I would consider that an evolution of the landscaping trade that remains consistent with the definition of landscaping.
In 67, was Thayer Nursery doing that?
Yes, it was.
It was putting in slate?
I actually made inquiry to Mrs. Oldfield and asked her, what her husband's practice was, and he was making stone walls and patios at that time.
Okay.
Mr. Prondak, we notice you here, we welcome you. Would you like to be heard?
I would. Joe Prondak, building commissioner for the town of Milton.
Thank you, Joe. We'd throw our back out if we tried to do something like that.
Not far from it. A couple of things. I do believe that the Thayer Nursery's nursery operation is protected by the Dover Amendment. I don't believe the landscape construction business is protected by the Dover Amendment, but I believe it's allowed by the special permit. There have been occasions where my office has issued building permits for Thayer Nursery to build steps on houses. They have built raised patios on houses where the alternative or the options for the owner was to build a wooden deck or a stone patio, and the owner chose to build a stone patio, which Thayer Nursery did. So that, in my mind, is just construction, not landscape construction. I've been to both sites. I've been to Thayer Nursery, I've been to Mr. Rowe and Mr. Johenning's property. I do believe there are some violations of the special permit. In some which tonight Mr. DeLuna said there were not. But what I'd like to get at first is that the whole premise of the appeal, Mr. Johenning and Mr. Rowe asked me to enforce the special permit, and I denied enforcement because I felt there was a pending court case that is in fact challenging the special permit. And it's unclear to me, and I think to the board and to everyone, what is the status of that special permit. From what I understand, the former abutters or the abutters who had an interest in that case have dropped their appeal. I've spoken to town council. The town of Milton has no appeal against Thayer Nursery, so the only possibility of this pending appeal, this appeal that's languished for 10 years, would be that Thayer Nursery is the complainant. So if, as Mr. DeLuna stated tonight, he doesn't know what the status of the appeal is, then I would wonder, can we just consider that appeal to be abandoned and they're no longer going to pursue it? Because if that were the case, if there were no appeal pending, then I would have agreed with Mr. Rowe and Mr. Johenning, and I would have taken some enforcement action, the extent of which is simply to refer the case back to the board. And if we assume for a second that that were the case, and I did refer it back to the board, it would be my suggestion that the premise of the special permit has changed, in that the nature of the business has changed. And not only should the board look at what we see as violations of the special permit, but that the special permit needs further conditioning to control current conditions. So that all being said, I think it's a big, important question. What is the status of the appeal? And it would be mind-boggling to me that if Thayer Nursery couldn't answer that for us. And if there is no appeal, then I think I would change my decision to Mr. Rowe and Mr. Johenning and simply ask this board for consideration of what we perceive as violations, and I would spell those out, and I would ask for further conditioning due to some of the changes that have occurred on that property. With respect to Mr. DeLuna's, a couple of things that he mentioned, no parking on Hillside Street. I have direct communication with Chief Wells that on several occasions for whatever particular events, that parking has occurred substantially on Hillside Street, to the point where Thayer Nursery had their own employees geared up with reflective vests directing the parking on Hillside Street. We have complaints from abutters that stem from noise, and most particularly music that occurs during certain events that occur there. We have complaints that go to damage that is being caused to the public roadways by delivery trucks that come, tractor trailers that park and idle and sit on the side of the road and off of the edge of the asphalt. Those complaints come not only from the abutters, but from our Director of Public Works, Joe Lynch. There is a sign on a gate at 217 Hillside Street, which is in violation of the sign bylaw. I've had questions from abutters as to what are the hours of the operation of Thayer Nursery, and in all of the special permits, all of the conditioning, there are no restrictions on the hours of operation of the nursery. There are only restrictions on the operation of the Bobcats. So I also feel that it's not, if, say, a nursery wishes to continue to operate their commercial landscape business under the guise of the special permit, I don't think it's fair, not that this has necessarily happened, but I think they should be willing to accept the fact that the board should be able to condition the entire operation and not say, well, for example, I'm getting a delivery of trees by tractor trailer that are going to go in the nursery, and they're gonna come at 4 in the morning. And as unreasonable as that may be or offensive to the neighbors, it's protected under the Dover Amendment. But we'll agree to a condition for tractor trailer deliveries that are related to the landscape business. So I'm just trying to set out an example of some of the things I see as an issue here.
Let me say a couple of things, Joe.
Yep.
Number one, as remarkable as it may sound, a case getting lost in the land court for 10 years is not necessarily an unusual event. If the court is a relatively new court, and they've been moving all over the place, and they're devoid of resources, and they get involved in some very, very specialized and technical decisions. And it's an expensive place to be, because they practice like the federal court there. They require a lot of intense memoranda and preparation. So it's not it's disappointing, but it's not surprising considering the limitations that are placed on the court that it's taken this long. You can go over to the Middlesex probate court, and they can't find wills over there, and they can't find complicated cases. So, and that has put you in an unenviable position, because I know how much you preferred to have that case decided. And so we appreciate the position you've been in, because I think you've been in that position because the board has put you in that position with our series of decisions. Mr. Dunn's analysis of the situation is that he believes that irrespective of what we write in special permit decisions, this is not a use which is permitted under the special permit process. And that it's the bedrock of his position, at least I understand it, is that he believes that the only way you could operate a landscaping business on this property or any other nursery in the town of Milton is with a use variance, which he insists they have not secured.
If I may just clarify this
Sure,
point,
Mr.
and it's close, your statement of my position is close, but it's not exact. I am asking that the board enforce the bylaws of the town, not the 2002 decision. As well reasoned as the 2002 decision is, it doesn't address whether the use is permissible. And by the uses, I mean the landscaping and the construction and the retail sales. Particularly, I recognize that in 1967 that the scope of the landscaping business could arguably be viewed as accessory. And if you look at the language that my brother quoted, Mr. DeLuna, it says the business consists of growing shrubs, flowers, vegetables, plants on the premises, and selling them, meaning the items that were grown on the premises, which does and does not occur at this time, to the public. Conducting landscaping business from the premises whereby shrubs, plants raised on the premises are planted at distant locations, the retail sale of fertilizers, pesticides, etc. So what you have here operating today, the landscaping business, is not the same landscaping business that was contemplated as being accessory back in 1967. You have, it's much larger in scale. It's using products that are not raised on the premises. to be used, and these are products shipped in that are used off premises. So you basically have 270 Hillside Street being used as a staging area to store imported materials to be used off-site by this landscaping business. Certainly not what was contemplated here. So, you know, if they're going to scale back the landscaping business, then I could see how an argument could be made that the scaled back scope of that landscaping business to the 1967 level may be permissible. But as it's being operated right now, it's a standalone business. And as a standalone business that is not accessory and not incidental to the permitted use, which is a nursery, it does need that type of zoning relief, which would be a use variance. And that's the same with respect to the construction aspect of it. Now, one other point that I'd like to make is that there's been a lot of talk about the 25% sale of products. And now that pertains to products agricultural products that are raised on the premises, meaning you can grow this stuff and you can sell this stuff on the property, and you can sell 25% of it. Now, the big flaw in the reasoning here that's been presented by Thay, just because you sell 25% of agricultural material, it doesn't mean you can sell anything with regards to the 75%. It's got to be related to the activities that are transpiring on the property. And that's what my clients take issue with. The 75%, I mean, it's like I said in the brief, it's a very attenuated logic to say that lawn furniture is accessory or incidental to selling a pine tree. That's really a leap of logic that we're just not willing to take. And the same thing goes with the uses on the premises. The 25% does not create this umbrella protection for uses that are otherwise impermissible. So that really goes to the heart of what my clients are asking for. They're asking for enforcement of the bylaws, not necessarily the 2002 permit, and that the uses that I've already identified are not permissible under the bylaws. There's zoning relief that's required that hasn't been obtained, and that's it.
Do you have anything? I'm sorry. Yeah, go ahead, Brian.
I was just going to say in response to that, just so I'm clear on this. First of all, I put 48 Section 3 to the side. From my perspective, that's not on the table tonight. In 1967, the Board of Appeals authorized the business of landscaping, whether in connection with plants sold or not from the premises. Not model words, but I think I understand what they meant. So that, in 1967, by the special permit, the Board of Appeals authorized landscaping at their nursery. Period. Full stop. So that begs the question, then, what does that mean? What does landscaping mean? But let me finish. So in 2002, when a zoning enforcement action was brought, the Zoning Board of Appeals, and I wasn't part of this, I'm just reading the words, the Zoning Board of Appeals said, we don't think it's a 48.3 protected use. The decision, rather, is based upon the board's enforcement of the June 1st, 1967 special permit and the board's power to regulate the accessory commercial landscaping operation presently being conducted, which is not, I don't think, significantly different than it is today. It had some of the elements, maybe it's changed in quantitatively, but probably not qualitatively from what it was in 2002. So the board decided in 2002, as I read this, that the use in 2002 was okay, but that they were going to impose some additional conditions. And as I understand it, the people that brought the zoning enforcement action dismissed their appeal. So
Of which my client was not one.
I understand, but that issue has been decided in 2002. And as far as Mr. DeLuna's appeal goes, I don't think the appeal related to the conditions, did it? The ones that you've taken us through tonight that, and you say you're in compliance with?
I'd have to go back to my files.
It strikes me that the only thing you would have appealed would have been the ruling in the decision that it wasn't a 48.3 protected use.
Again, I would have to go back to the precise language.
From my perspective, being someone that spends 90% of my practice in the land court, I don't feel that an appeal that's pending from 10 years ago much constrains us at all. As far as I'm concerned, the issue has been decided, and that the special permit authorizes a landscaping operation. And I frankly would love it if Mr. Prondak would assume that to be the case, and to recommend to us, because you know far more about this than I do certainly, maybe not Mr. Leonard, the kind of additional conditions that you would impose in light of current circumstances. I would find that very helpful. And I don't think you should feel constrained by that 2002 land court action. I think it's unlikely that the case is lost. I mean, I don't find that they're lost. What happens is, for cases that are very old, they don't bother themselves with them much anymore. They don't go looking for them. It's not like the Superior Court where they call a list and start dismissing cases that aren't being prosecuted. If somebody doesn't take affirmative action to get it prosecuted, it will sit there forever. So I think if we went over there, I bet you we could find it, and we'd find that the docket would show that nothing's happened for 10 years, and that's it. And as far as I'm concerned, I don't think we're constrained because there's some old appeal that's sitting in the land court that's not being prosecuted. So as far as I'm concerned, this decision stands. It stands for the proposition that a commercial landscaping operation is okay. It imposed some additional conditions. You have found, apparently, based on your observations, that there's been some additional violations of perhaps both the original and the 2002 conditions. And so then the question is, what do we as a zoning board of appeal do with that finding by you? And we have, it seems to me, two options. Either we take the draconian measure of saying, well, we think we're going to revoke the special permit, which I certainly would not be inclined to do, and would perhaps be tarred and feathered if I even suggested that that was something that we would do. But I would be inclined to consider additional safeguards and conditions that would further protect the neighborhood. I mean, that would be my inclination, just to give you my thinking at the moment. And I would love it if my board members agree with me, to get a list from you. I mean, we may embellish it, we may add to it, we may delete some of them, but I'd love to have a starting point from you, Mr. Prondak, as to how to do that. Anyway, sorry.
Thank you. No. Ms. Beckworth, how are you doing?
I'm doing okay.
Okay, do you need a break, or are you all set?
I'm okay.
Okay, fine.
Respectfully, I'd like to request to, we need to address the board.
Well, you can do that, but it's not the appropriate time. Just hold on for 2 seconds till we make sure. Mr. Prondak, are you all set for now?
If I could just add to Mr. Hurley's comments, given that reasoning, I would almost welcome an overturning of my decision by the board, if you so chose to go there, in which case we could then start a process, which I believe is how it should happen. I believe that before this appeal rose to this level, Mr. Johanning and Mr. Rowe indicated that, look, the problem here is odor, dust, and noise. And as I've been to their property, I've stood by their pool, I've been to Thayer's property, I've seen the stone dust piles and the mulch piles. It doesn't take a rocket scientist to know that if you're out on a Saturday afternoon with your friends having a party at your pool, and there's a light west wind blowing, and Thayer Nursery overturns their stone, or loads a truck with stone dust, it's gonna cover that pool with dust. Or if they overturn the mulch pile, it's gonna create a horrendous odor. So I think, and other things that we've mentioned, like noise and parking, all of that, I believe, is controllable by Thayer Nursery, very much so. I don't, I'm almost willing to say that to deal with this at this level is almost unnecessary. What we need is much as we did with Milton Hospital years ago, to sit down with all the parties and work out some conditions. There has to be, unfortunately in this case, there has to be a means of meaningful enforcement. Because, for example, if the board said, no parking on Hillside Street, or on Parkwood Drive, and then two customers parked in front of Mr. Johanning and Mr. Rowe's house on Parkwood Drive. As it's written right now, my only enforcement ability is to refer it back to the board. which means a public hearing and advertising and all of that, just for 2 cars parking, but there, I believe it may be within the board's power to set up some sort of a graduated fine system or ticketing system of some sort that I could impose, and I'm just thinking out loud at the moment, but to simply impose conditions and then the only enforcement is back and forth to the board, we'll be doing this for the next 20 years.
You will be. I won't be. But I appreciate your comments, Joe. We put you in this position, so it's not any reflection on your lack of diligence in enforcing the special permits.
And I believe all of this can be worked out if we were to sit down and work it out.
So,
That's my thought.
thank you. So we've heard from the lawyers. I think they've said everything they need to say, but Mr. DeLuna wants to say something else. Go ahead, Mr.
A couple of things. First of all, before anything gets closed, there is a letter that was presented to Maggie tonight. I have not seen it since there are emails and stuff in the record.
And this can be a dangerous proposition presenting to the board, Mr. DeLuna.
Mr. Carlson used to.
I'm sorry?
So are you offering this?
Yes.
All right, let's see what this is while you're walking back there. This mysterious communication. This is a letter, 8/15/2013 from Richard A., I think it's Moken, though it could be Mochin, of 555 Harlan Street, Milton, and he's a long-term resident of the Hillside neighborhood, and you can say that Thayer Nursery is only an asset to the community. The business goes out of its way to respect their
I'm
neighbors. I am very sorry.
That's okay.
We don't have reporters here
It's
often.
an
The-
asset to the community. Business-
Period. The business goes out of their way to respect their neighbors and the town. And he fully supports the operation to continue and carry on with business as usual. Best regards, Richard A. Mochin. So we thank Mr. Mochin for his letter. Did you have a second thing to add, Mr.?
Yes, two things. First of all, the allegation that this is a standalone business is not a valid allegation. What is installed by Thayer Nursery is nursery product that is grown by them, and the landscaping is surrounding their nursery products. And I do believe that the November site visit, it was demonstrated that the Thayers are in substantial compliance with the 2002 amendments to the special permit. And during that site visit, very similar circumstances that our building inspector raised were addressed. Maggie, or Thayer Nursery, has told drivers that they're not allowed to make deliveries in certain hours. Those have occurred in the past. To the best of my knowledge, those are not recent occurrences. So again, I believe that Thayer Nursery is in substantial compliance with all the conditions that have been imposed.
Thank you, Mr. DeLuna. Okay, it's 9:30, folks. We generally adjourn these hearings at 10:30 because people tend to fall asleep after 10:30. So what I'd like to do is see if there's anybody out there who perhaps has a comment or two, and then see if we can move on and at least discuss this, if not decide it. Yes, ma'am, you had a comment. Do you want to come up here, please, so you can be recorded in TV land?
Thank you, Mr. Chairman and Board. My name is Cheryl Flightman, and I'm a Precinct 1 Town Meeting member.
Speak slowly.
And where do you live, ma'am?
75 Crown Street.
Thank you.
And
Good, welcome to the Board of Appeals.
Thank you. I have known Mr. Joe Henning for just a short time, but I've known Mr. Rowe for a very long time, having worked with him in the past. And I think the fact that they haven't lived in the town very long is not to their advantage, because so many people know the old fields and are so familiar with Thayer and respect them. And I was really surprised to hear that you've received so many emails, which I'm sure are in support of Thayer. I didn't know that anything could be submitted on behalf of Mr. Joe Henning and Mr. Rowe. So one of the things that I would like to say is everybody seems to forget to bring this down to a personal, day-to-day level. Mr. Johanning and Mr. Rowe have the civil right to live in quiet, peaceful enjoyment of their home. I don't know how many of you have seen their home, but their home is exquisite and pristine. When you go into their yard, it's beautiful, looks like a resort. I've been lucky enough to be able to enjoy their pool. I have been over there several times, and all of a sudden you just start hearing beep, 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 beep. It's pretty annoying. And if you go to the back fence and you look through, there's dust, there's dirt, there's rocks. If there was no fence there, it would be horrific. I've also been there several times when all of a sudden you get the odor of the manure. I don't think anybody in this room would want to have to live under those conditions. And regardless of how well Thayer is respected or what type of business they are doing, they should understand that too, because they wouldn't want their home life disrupted by that. They can leave the business, they can go home. Mr. Johanning and Mr. Rowe have to live with it, and I think that's really unfair. And it made me laugh when you gentlemen were talking about doing a view and letting them know in advance. It's kind of like having company coming and knowing in advance, and you hide everything and you throw things in closets and put all the dust away. And that would be done. Somehow they would manage to keep that property looking pristine so that anybody looking at it would say, this isn't so bad. But if it was a surprise visit, say as a social worker would be a different story. Thank you for your time.
Great, thank you for coming this evening. Oh, of course you may, please.
I'm from Texas, so I can do that. I'm Dr. Cindy Christensen. I live at 59 Collimer Street, Milton. I'm town meeting member, Precinct 7. I've had the good fortune of recently, just this past summer, being over at Mr. Johanning's and Mr. Rowe's home, where they hosted a meeting for a grassroots committee that I serve on with them. After they showed me the interior part of their beautiful home, I said, can I see the outside? And the first thing I noticed when they opened the back door were two things: the noise and the stench. So I, not knowing them that well, tried to not say anything, like, what in the heck's going on? Why is there this beep beep, this loud sound of machinery? Walked out further and actually couldn't even get all the way back to the back fence because of the smell of manure. Now, I've heard the council say they don't store manure on their property, and I was really surprised by that because, as I just mentioned, I did grow up in Texas and I know how manure smells. The last thing I wanted to mention is more of a town issue. As I was leaving this meeting, I was very concerned about the off-road vehicles with workers from Thayer being on the city streets. These are unlicensed vehicles that I was passing by as I was leaving their home, and I think if there are further restrictions put on Thayer Nursery, that's one that should be included. These unlicensed vehicles should not be on public streets. Thank you very much.
Thank you very much for appearing. Is there anybody else out there who'd like to be heard? Mr. DeLuna.
A point of clarification, the only manure that is sold at their nursery is bagged manure, and it is actually kept undercover. So the allegations of manure, I severely question.
Oh, I think I see Mr. Prondak's hand. Joe?
Just a further point of clarification, I think the odor comes from the mulch pile, which is directly behind Mr. Rowe's property. I believe it is not, I agree, it is not manure, but boy, oh boy, when you turn that over and it's been sitting in the sun, it generates that internal heat, that smells like manure.
Great. So if nobody else wishes to be, yes, sir.
I'd like to speak on behalf of the Oldfield, if you don't mind, please.
I don't mind. Come on up here.
My name is Richard Bonomi. I live at 60 Forest Street. I'm sorry. My name, Yes.
Benoni?
Bonomi.
Would you spell your name for the reporter?
That's B as in boy, O-N-O-M-I.
And your address?
60 Forest Street.
60 Forest. Thank you. Welcome to the board.
Thank you. I'm in a butter within 200 feet of Thayer Nursery. First off, let me explain. I'd like to explain the landscaping. When I was an ag student at the agricultural school in Walpole and also Stockbridge School of Agriculture, before I entered that was in the early 60s, like 62. It was called landscaping. They quickly changed it to landscaping, architecture, and design, which takes in a multitude of stone, slate, or any natural product that someone might use or manufactured. So it doesn't just stay with shrubbery anymore. And let's get to the point of a couple of them.
Of what?
A couple of points on the care of the premises over there, and maybe some vehicles on the street. The vehicles on the street groom that street and all the rocks that are in front of the Oldfields property continually. They pick up all the trash that everybody else throws out on the road that goes through there. And the manure. The manure smell is probably from all the horses that are up there. Go into my garage probably any day of the week, and it's probably when I ride over it on the street, it's in my house. I don't get out and knock on the people's door. I welcome the agriculture in the area. I welcome the commercial base in this town, which this town, for some reason or other, wants a commercial base, but they scrutinize it unmercifully when somebody runs a business that has been there longer than most people have even been alive, even everyone sitting at this table. No offense, okay? So I support them. I never seen an odor or dust. And now let's talk about the parking. I walk my dog continually, so I smell no odors there. I walk down Parkwood. And the traffic. Why is it that when somebody's making a delivery or doing something that is for the benefit of the town, whether they're having their fall festival, their Christmas tree sale, which everybody kind of celebrates or does something. Everybody's visited, everybody's bought a product up there. Why is it that there's just a certain few neighbors that walk around telling people and complaining about the old fields? And I've seen this continually. They've approached me, the complainants in particular, and other people who park their cars on the street to purposely hinder the traffic. I've watched the Christmas fairs with police details. Yes, sometimes it's overwhelming, but it's only for generally that one day on that Sunday. It is a holiday festival season. Don't we really need this in town? I really don't. I'm sure there's a complaint from mulch. When I spread mulch around my house, I smell it. We all smell it. Okay? I'm sure that they smell it a little bit more when it's overturned. Okay? It's the nature of the business. But it is not an offensive odor. Okay. I have no problem with it whatsoever. I built my house up there in 1987. I knew Bob when he bought the property. I had people that I went to school with that worked for Bob back in the 60s. The whole agricultural, the whole nursery and landscaping business has evolved into something completely different. We all participate in that, whether we want to buy a stone bird bath from them, we want to buy grass seed, or we want them to come in and say, what kind of landscaping and architecture design? So
we want them to come in and say.
and re-landscape and architecture our property so it is pristine like anybody else's. And that includes whatever stone driveway you want, stone wall, patio, or any ornamental, I want to say, patio furniture that you might want to have. So it's all part of the business. There isn't a landscaping and architectural design business, no matter where you go in this country, that doesn't partake and sell what they have. So I'm a complete support of what they are. And every business in the world does something wrong. We all know that. But you can work with them very amicably if you try. Okay?
Great.
Thank you.
Thank you very much, Mr. Benoni. Is there anybody else who wishes to be heard? Yes, sir.
Trying to talk slow fight.
Thank you.
My name's Stephen Tanzer. I live at 21 Sumner Street.
45 years old. I've lived in the town for all but 4 years of my life. I've known the Oldfields almost my entire life. They've done a ton for this town. The father, like, went out of his way to do stuff for the town. And I think, you know, people move into the town, and they were already there, and you sort of know what you have there. I mean, you have multiple farms up there. So when you're talking about odors, I say the same thing. I'm driving through there all the time. I'm riding over the horse manure in the street. I'm not complaining about it. It's part of what goes on up there and has always gone on up there. I just want to say, you know, that I think they do go out of their way to do good things, and I think the town should consider that.
Great.
Thanks.
Thank you, Mr. Dennison. We appreciate it. Anybody else want to be heard, or is that, yes, sir?
Sure.
Yes.
Hi, Phil Lang. I'm actually Maggie Oldfield's husband. I live at
Good.
237 Hillside Street. I had a few questions. One is about the 1967 permit and growing a business from then. And it's very, I mean, I'm a business owner myself, too. I'm a carpenter. I have nothing to do with the nursery business. But if I was doing things the same as when I didn't start my business in 1967, it was 1990. And if I was doing things for the same as I did in 1990, I wouldn't be in business today. It'd be impossible for me to do the kind of business, like you mentioned pavers. If I was doing Korean countertops today, I wouldn't be able to keep my business going. Like, you need to grow with the economy and what changes and that kind of thing. I mean, they need to do things to keep their business going. It just would be impossible to keep something alive with, you know, if you put constrictions on them that they have to keep going in years to come. Sorry, I'm not a public speaker, not making sense, but if, yeah, so if they have to agree to certain restrictions today, it's very difficult for them to do that because they don't know what is gonna come in 10 years from now, or 15 years from now, or 3 years from now. They might have to change. I think that's why they're nervous about agreeing to certain laws or conditions that you guys are going to put on them. I think you just need to put yourselves in their shoes, and if you had a business that someone was going to come in and say, listen, you have to do this for the next 20 years, it's very difficult to wrap your head around that. Like, you know, in your own business, just put yourself in their shoes and kind of consider that. That's about all I have to say.
Great.
All right.
Thank you, Mr. Dennison. So if nobody else wants to be heard,
I would like to be here.
you certainly have a right to. You have Mr. Dunn, but you can be heard on your own.
All right.
Sure, why don't you introduce yourself, sir?
My name is Phil Johanning. I understand, you know, everything about being in business and wanting to be successful, and I believe the Oldfields are. I believe they have a beautiful establishment that faces the road. Me, not so much. I'm not trying to hurt the Oldfields in any way. All I'm trying to do is to say that there are certain aspects of the business that need to be moved to a commercial district. And then there are other uses that can remain with my blessing. I believe we can both coexist very happily when they continue as a nursery and all of this commercial construction activity is relocated to Randolph Avenue. There are, A. Thomas operates extremely successfully on Randolph Avenue. Part of his facility is agricultural, part of his facility is commercial. He pays tax as a commercial business to the town, and the town benefits from that. They paid tax as a farm, and the town benefits not so much. So I guess I'm saying we can coexist, we can be happy,
They can continue their nursery business with my blessing. I think their facility is beautiful. I think we could be good neighbors. But I think this aspect of their business is creating a lot of friction and has for many years. And I think there are a number of businesses like Driscoll, who houses himself at the Pepsi plant, which is basically right around the corner. It's a commercial, it's zoned as a commercial area. They can keep their trucks at the Pepsi plant. I don't know. But I think, you know, if this kind of thing is kept at the Pepsi plant, great. You know, I don't wish them any ill will. I want them to be successful. I want them to continue to keep their property as beautiful as it is, facing forest and facing hillside. I think I can get along very, very well with the Oldfields. But this, I think, has gotten to the point where it's beyond, you know, beyond something I can live with. There, you know, there is a lot of noise before 7 in the morning on weekends. I have a log. I didn't bring it with me, but I note every weekend day when I'm awakened by bobcats backing up, beep, 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 before 7 o'clock in the morning. You know, I am entitled to some peaceful enjoyment too. I understand they have a business. I understand they want to be successful. I want them to be. But I also want peaceful enjoyment. I get up at 4:30 every morning to be at work in Lakeville by 7:30. You know, I need rest. I need peace. You know, I have a swimming pool in my backyard, which Cheryl alluded to, and I think Cheryl was more, you know, was clearer on all these points, but I wish to repeat what she said. You know, I take great pains in my yard, as the Oldfields do on their property, and I would like to enjoy my pool without having dust landing in it and having to vacuum it like, you know, several times a month. I would like not to smell manure in my backyard. I don't know what you call it, but it smells like pig manure to me. And I know manure too. You know, I want them to be successful. I want to find common ground with them. But this can be relocated to some other place. I think it's divisible. I think it's possible to move it. And I think that would cause us all to be very happy neighbors. Okay?
Great, thank you, Mr. Jai.
Sure.
I assume nobody else wants to be heard. Thank you. So what we're going to do is we're going to close the formal part of the proceeding. It's now 9:47. Our reporter needs about 10?
Just took the restroom break.
Okay, so about 5 to 10 minutes, maybe not quite 10 minutes. And then the board will discuss this application and we'll see where we go with it. So we'll be adjourned until, let's say, 9:55. Now 9:56. So we're going to resume the hearing. As you probably know, the board's obliged under the open meeting law to discuss the case in open session and vote on it. And we intend to do that here and now. The board is a kind of a strict constructionist with respect to the open meeting law. And we never discuss these decisions other than in open session. So I don't have the slightest idea what my colleagues think of the evidence and the application and the law. So we may go around a little bit on this particular application, which I think is complex. I want to start out by just thanking the attorneys and the public for their participation in this hearing. Mr. DeLuna and Mr. Dunn have been before us before. They're outstanding lawyers. They have expertise in this area. They filed absolutely first-class memoranda, legal memoranda and materials, and from my viewpoint, they made every argument and sometimes more than to support their client's position. And in my view, they comported themselves with, in the highest traditions of the trial bar, so I thank them for that. I want to thank the members of the public who appeared at both public hearings and sent emails. It's very important for us to get public participation. We review all of the written materials, we listen to all of the public comments, and we weigh them accordingly. It's very important that we listen to the public. I saw an article in the Globe the other day. You may have seen it too. It's on the front page of the Globe. And essentially it was talking about the lack of public affection for the Congress and the doings in Washington, D.C. And it said that some of that rancor has been found in local board administrative hearings, both before the Planning Board and before the Board of Appeals. And they thought that was moving in the wrong direction. I can tell you here that everyone involved in this proceeding, both those who have testified and, in my view, those people who have written support, petitions of support or in opposition, who are acting in utmost good faith, expressing their views candidly and fairly as they see them. And I've been chairman of this board for probably 15 years, maybe a little bit more. And I can't think of an instance where we've had to reprimand anybody for improper conduct, character assassination, or otherwise. So I really want to thank everybody. These are hotly contested issues. They're important issues. But everyone has comported themselves, in my view, in an outstanding and wonderful manner, and we appreciate that. Since I speak so much at the public hearings because I control the evidence and the participation of people, I think it's probably best under these circumstances that I hear from my colleagues first. So I'm going to ask Mr. Hurley to address these issues in the first instance.
Thank you, John. I just let me reiterate all the things that John said. This has been a well-presented public hearing, and we do value what everyone has to say about what is clearly a very difficult situation and topic for all of us to deal with. And I appreciate the lawyer presentations and just generally the whole demeanor of the people who have made presentations here tonight. As some of you may have gleaned, and maybe I've even said it expressly, I spend all of my professional life as a litigator. I do exclusively real estate litigation, and I have for 35 years, and a fair amount of that is zoning litigation. So in fact, I have a brief due in the land court tomorrow at noontime on a zoning case. So I'm familiar with the terrain, and maybe that's sometimes a bad thing because I can sometimes take a fairly lawyer-like view of things. But sometimes I think it's a good thing. We very much appreciate, both from the testimony that we've received and certainly from my own personal experience, the value that Thayer Nursery brings to the town. I've been a person who's visited and made purchases over the years. I've never asked them to do any landscaping, but I certainly have done a lot of purchasing there, and I've observed personally that it's a perfectly well-run operation and a credit to both that neighborhood and I think to the community at large. And I hope that the Oldfield family appreciates that all of us on the board, I think, share that sentiment. But on the other hand, there's a balance that we have to strike in cases of this nature, particularly where it's involved with special permits, which are inherently discretionary forms of relief that are granted by zoning boards of appeals. They're not like variances and they're not like building permits. There's an element of discretion that's built into them, and typically because of that discretion, they are buffeted, if you will, by conditions that are imposed that are designed, or at least intended, to ameliorate some of the recognized impacts of those special permits. And here we have a fundamental tension between a nursery business that's situated in the midst of a wonderful neighborhood, and by all testimony, it seems that the nursery has done its best to strike that balance. But obviously, there are situations where some neighbors quite rightfully feel that they're being adversely impacted. And so the tension then is for us to figure out what to do to try and accommodate those various competing interests, and that's what I hope to do by this decision tonight. The way I look at the evidence, it strikes me that we start with a 1967 special permit. You know, we allow a landscaping use. If you read the decision in 1967 carefully, it actually contemplated that over time the conditions might change, and that from time to time conditions with respect to that special permit would have to be revisited. They were somewhat visionary, I think, in realizing that businesses of that nature aren't static, nor should the conditions be static. And historically, that's exactly what has happened. On more than one occasion, the matter has come back to this board, once in the form of an amendment to the special permit, and then in the early 2000s in connection with the zoning enforcement action. And the upshot of each of those returns to the Board of Appeals was that additional conditions were implemented with the hope, obviously, of trying to achieve that balance, at least at that point in time. And whether that's successful or not remains to be seen. But certainly, those kind of conditions also contemplate that there'll be an element of good faith on both sides, both in terms of fairly and honestly complying with the conditions on the one hand, and on the other side, recognizing that people can't always achieve in the real world, can't always achieve compliance with some of those conditions. So that's how I sort of see the context of how this case comes back to us. So a new zoning enforcement action is commenced. Unfortunately, apparently there was no ability to sort of mediate those issues between the two interests. It falls on Mr. Prondek's lap as the zoning enforcement officer of the town to deal with that kind of an action. And understandably, but I think ultimately incorrectly, he decided that he couldn't, even though he saw violations, he believed and concluded that the landscaping operation itself was properly within the scope of the special permit, but he did feel that there were a number of violations, but he felt constrained because of the existence of the 2002 lawsuit not to issue an enforcement order, as I think clearly he would have done, unconstrained by that decision. I think I've persuaded him tonight that he's not constrained by that decision, and that indeed he should have gone about the ordinary process of issuing an enforcement order and returning it to the board for imposition of conditions. So my view, just to put this in a capsule, is this. I would not be inclined to revoke the special permit. I would be inclined, although I'm not completely free from doubt on this issue, I would be inclined to say that the modern day landscaping operation falls within the purview of the 67 special permit as it has been amended from time to time. But I also feel strongly that we need to develop more complete and comprehensive conditions that are clear and enforceable, that will deal with issues like what we see in that photograph in front of us in terms of visual impacts and odor impacts and all of the impacts that would be associated with this kind of use. So my inclination would be to vote to overturn Mr. Prondek's decision, effectively remand the matter to Mr. Prondek, asking him to do what he would do in the ordinary course if he were to issue an enforcement order. He advises me that one thing that he would likely do would be to attempt to sort of mediate or agree to a set of conditions and failing that, he would return to the board and with recommended conditions for us to impose in light of his efforts to mediate with the competing interests that are before us here tonight. So that would be my inclination. The competing interests that are before us tonight. That would be my inclination, John.
Okay, very good. Thank you, Mr. Hurley. Mrs. King, do you want to be heard?
Sure. I do see that there's very legitimate issues here that the petitioners have brought to the table, and they do need to be addressed. Would it be so violent as to revoke the permit for the business at Thayer Nursery? And my answer to that is definitely no. Would it be that we need to have more conditions so that everybody does get to enjoy the land that they own or the bank owns, and that the business can run, that the petitioners can enjoy their backyard? I guess we have a little bit of a quirky situation here where I'm just wondering what we do as far as procedurally, if we were to be unanimous in overruling, is that what we do? Overruling Mr. Prondak. Is that what gets this going into that process where there can be some kind of conditions brought before, that you'd be mediating between all the parties?
Well, I think that's right, but why don't you go through with how you see this analysis, and we can decide
Okay.
the procedure if we see if the board's in agreement on all of these issues.
I'm not convinced that the landscaping business, as it's been brought forth today by represented today by Thayer Nurseries, is something that was anticipated in the 1968 decision. So I might be a little harsher than my colleagues might be about the piece of the business that has to do with the hardscaping of a yard. But I do feel that the business should be preserved, not perhaps the landscaping portion of it on this site, meaning the hardscaping, landscaping, should be preserved on this site or not. I think that might be something that we want to look into, because it does seem that this land is being used very, very heavily in a manner that is not conducive to a residential zone. So that's my thought on it.
Okay, well, I thank you very much, Virginia. Let me, if I didn't do so originally, I hope I did, but if I didn't, I obviously want to thank Joe Prondak for his good faith efforts here. We put Joe in a difficult position with some of these special permit decisions, and he's in a proverbial between the rock and a hard place, and I think he's really done a wonderful job to try to bring about some sense here, and we thank you for it, Joe, we really do. I think my view of this differs just a little bit from my colleagues in several respects. Number one, I really think that the town should be appreciative that we really have 3 outstanding nurseries and landscapers in Milton. They're, I think, friendly competitors. They're all wonderful families who have deep roots in the community. They sell wonderful products. They're all involved in charitable endeavors like Thayer Nursery here. They take little parks and whatever you call these little gardens at various locations and turn them into beautiful flower placements, and they really beautify the town. We're very lucky to have them. And I think, as Brian said, and I agree with what Brian's analysis was, the board over the years has had to deal with nurseries and how they expand and how the nature of their business changes. And we did begin in 1967 trying to regulate the landscaping aspect of the business under the special permit route. And we did that because at that time, in at least my memory and my view, that the landscaping part of the business was really very small. It wasn't a major league operation. It was all very small. And it gradually increased, and at least as of the present time, one of the affidavits, which I probably won't be able to find here, filed by Margaret Oldfield, says that in 2011, 41% of Thayer Nursery's customers were provided with landscape services. And in 2012, it's 38.9%. So it's grown from something that is perhaps incidental and perhaps as a courtesy to the various customers to something that is a substantial part of the business. And I think by looking at our 2002 decision, and I apologize, but I'm going to be a little lengthy here, but I think we've listened to you, and I'm going to force you to listen to me. This certainly says several things. It cites the Massachusetts law, which says that ancillary uses can't blossom into extensive retail operations divorced from its roots. And in this 2002 decision, we find that in the 1987 commercial landscaping business of Thayer, while we say it was an accessory to the primary use, it's been expanded in volume and intensity so as to be divorced from its roots. And the board kind of had a turning point here because we were commenting that the commercial activities and the landscaping activities, they were substantially above the 1967 levels, we note, and that the applicants, one of them being Mr. Rutecki, who was the former predecessor owner to Mr. Joe Henning's residence, was saying that the noise, dust, and the intensity of the commercial landscaping activities impaired the residential character of the neighborhood and affected his dwelling. And I went back and looked at the complaint, and he was complaining that there was noise, there was dust, there was debris, there was some tossing of materials on his property, and that he had various social events, including pool parties, that were dusted out because the dust was so intense that he wasn't able to use his pool. And so what we did here in this 2002 decision, we wanted everyone to be good neighbors. Well, that's nice. We talk about a respectful dialogue between the parties may be helpful. And we imposed additional conditions to try to protect the neighbors from those activities. And it included the very conditions that Mr. DeLuna related to. Bobcats with mufflers and the times that bobcats can operate and all of that. And we tried to do that to make peace and try to make a sensible decision of all of this. Regretfully, this decision wasn't reviewed in a timely manner by the land court, but I think Brian is absolutely right. I know Mr. Rutecki moved, I know he withdrew from the case, and my guess is this case has just sat there because it is moot and nobody wanted to proceed with it. But I think the tenor of this is really important because I think the board is saying in this decision at some point the commercial landscaping business is overtaking the nursery business here. And while we tried to regulate the commercial landscaping business under the special permit process, the question arises, well, how long do we continue to do this? I mean, we're not in charge of running people's businesses. And I don't think it's fair to either Thayer Nursery or to this board to make us micromanagers of Thayer Nursery, Eagle Farms, Thomas, or anybody else. I think we could be here till at least my predecessor will be dealing with these issues and probably having the same difficulty wrestling with these issues. So I can understand Brian's philosophy and his rationale, and it may be the route that we should go. But I have a deeper question, and this is where I need my colleagues' help. Since the latest decision of the Board of Appeals here, we have a written decision by Judge Sands of the Land Court in the Coulter matter. And Judge Sands tried to address some of these very issues, and they were all kind of talking about whether they can sell Christmas trees or wood or bird feeders. That's not what this case is about. We're not here tonight to talk about whether bird feeders can be sold or whatever. I understand Mr. Dunn's argument. I'm not overly impressed by it about plants and trees and shrubs being brought into the Thayer Nursery as something that's not protected under the Dover Amendment. I tend to think it is. But Judge Sands in the Coulter matter said he came to the central issuance to determine the validity of the landscaping business that was taking place on the Coulter property. And we've all stipulated, or at least the board has stated, that for the purposes of this particular hearing, we're not talking about the landscaping use being a protected use under the Dover Amendment. We said it wasn't in our earlier decision, and we've said it multiple times here. It's not. So the question is this a valid use under the zoning bylaw? And Judge Sands says that the zoning bylaws, the very Milton zoning bylaw that we're talking about here, authorizes neither as a use of right nor by special permit the operation of a landscaping business. And he defines what a landscaping business is, just as we've defined it and everyone else has defined it here. And he goes on to say, or the selling and storing of mulch, loam, fertilizer, stone pavers, dust, and gravel as part of such businesses. Looking at our bylaw, he concludes, these uses, the landscaping uses, require variances. And he criticizes this board for erroneously authorizing this type of use under the special permit process. And as a result of that, he finds that the various conditions on the special permit that we issued to Mr. Coulter are invalid, as they're authorized by special permit uses that may be authorized only by variance. And that's my trouble with all of this. I think sometimes trying to be helpful and cooperative and making people agree and helping people to work themselves out, that's always good. And my concern is whether we've gotten past that point at the present time. And Judge Sands in 2012, I believe it is, I'll give you the exact date of his judgment. It's May 3rd, 2012. He says the board can't allow landscaping under a special permit, even if we're trying to be nice about it, and that they need to use variance for this. And I'm not sure that I fault his reasoning, and that's one of my concerns here, whether we should just continue this under a special permit, whether we can even do it under the special permit process, or whether we should do it. I know that from dealing with several of the nursery cases, most of these vendors, great businesses in the town, have separated their landscaping business from the nursery business. They have moved their landscaping business off of the nursery. They've rented space in the old Pepsi-Cola plant, which, by the way, I understand is full and no longer available. They found private property or other property to rent for their pavers. I know over at the Pepsi plant, because I saw it as part of a view, there are pavers stored there, there's mulch stored there, it's covered, it's protected, the vehicles are inside. And so I think that other landscapers have dealt with this issue. And I wonder, from my view, whether the board can continue to deal with this on the special permit basis. And secondly, and maybe equally as important, whether we should. How much controlling of a business can we do? We have so many decisions, it's hard to figure out which conditions exist and whether they're still applicable and whether the law has changed and how the facts have changed. And I'm afraid we'll be writing special permits for till the end of doom, and I'm not sure that's in anyone's best interest. I tend to think that we should consider ruling that this use requires a use variance if it's to continue, and to give Thayer a reasonable opportunity in a business-like fashion to cease and desist from this type of operation at their present premises, and give them a modicum of time and cover so that they can rent suitable garages and storage yards so that the neighbors won't be burdened by these activities. Let me say this, because I have a big note, and I really want to make it clear. Mr. Joe Henning addressed the board. I appreciate his addressing the board. Nobody out there should be pillaring Mr. Joe Henning and the other particular petitioner for seeking to enforce their rights under the law. You don't need 10 neighbors to enforce your rights. You need one neighbor, and he is an abutting neighbor, and Mr. Rutecki was complaining for years that he was adversely impacted by this business. And Mr. Dunn told us that, and as did Mr. Joe Henning, that he bought this place in good faith. It's a beautiful house. I know the house. That he didn't mind being next to a nursery. He may have welcomed being next to a nursery because it's quiet and everyone loves plants and beautiful flowers. But he didn't buy into purchasing next to a construction site, and he didn't buy into the noise of a large-scale commercial landscaper. And Mr. Dunn introduced evidence galore here that on 4 or 5 instances going to Weston and these faraway places from this property, there was no landscaping involved at all. It was building of stone walls and driveways, and it was like a commercial construction project. And I don't think that's anything that's contemplated under this bylaw, and I don't think it's anything that we should be foisting on neighbors who think they're buying into a historic Scotswood district, a bucolic district, and find themselves all of a sudden next to a construction yard. So that's my problem with proceeding under the special permit way. I think that we can do it. Mr. Prondak can go out and talk to everybody. He's great at that. I don't think Joe is ever going to find accommodation here, because if it were going to be accommodation, it should have been long before this public hearing started. If this nursery was going to make an accommodation with Mr. Joe Henning, it should have been done months and months and months ago, and I wish it would have been done, but it wasn't done. And I think that the likelihood of that happening now is unlikely. I think we'll come back here if we proceed as suggested with another long list of conditions, like we're super operators of Thayer Nursery's landscaping business. I don't know how to run a landscaping business. I don't know landscaping work. And I think we're going to be met with a series, not necessarily just from Mr. Joe Henning, of complaints, of continuing difficulties. And I think secondly, that we're going to be faced with an appeal. And I don't mind people appealing. God love people that they can appeal our decisions. I tell everybody I'm the most sued man in Milton, and I am. But we render these decisions in good faith, but we're going to have Mr. Dunn standing up there and waving Judge Sand's decision and saying they ignored this decision. And I don't see a way around it, and I'd love to have Mr. Hurley help me on that issue.
I'm not sure I can help you. I'm familiar with Judge Sand's decision. I'm familiar with Tom Coulter's operation, and indeed, he's my landscaper, and he's had to find other accommodations as a consequence of that decision. So I'm aware of the hardships that are attendant. What I don't know, because I haven't drilled down on the decision, is whether there's been any change in the bylaw, whether the bylaw he was operating under was different in any way from the bylaw that existed in 1967. I just don't know the answer to that, and whether there was some authority for the grant of a special permit in 1967. I just don't know. But if there wasn't, if it was exactly the same bylaw, I tend to think it wasn't. But if it was the same, then it is a problem, because we've got a judge telling us that we're.
I'm sorry.
It is a problem because we have a land court judge who we know well, who is saying that what we're doing is illegal. I certainly can't ignore that. And I'm not trying to duck this, but I would like to find the answer to that question before we make a decision on what we do here. So it seems to me we could do 3 things, maybe more, but I can think of 3. We could take the Hurley approach, which maybe some view as not realistic, and that may be right. We could revoke the special permit based on violations, which I don't think we would want to do, and I wouldn't be inclined to do. Or we could say we think special permits aren't authorized under the bylaw. We don't think they ever were. We don't think there's any statute of limitations issues under 40A that we have to worry about. There's a few legal issues that we'd have to wrangle with before we came to the conclusion that we were going to revoke based on illegality.
Based on?
Illegality.
Thank you.
So those are sort of the 3 options that I see, and I very much appreciate what you're saying. I don't know how much longer I want to stay on this board, frankly. It's not because of these cases, because I just think it's time to pass on the mantle, but I certainly don't have the expertise in the nursery business or the landscaping business to make intelligent decisions about conditions. It's hard to know whether any of them are truly enforceable. I don't have a feel for that. I can rely on Mr. Prondak, but there's only so far he can go in terms of what you can do, because to some extent those conditions depend a lot on the good faith of the people that are involved. So it's really hard to know whether we're doing anything constructive by imposing additional conditions. I tend to think, when I sit on this board at least, that I try to find resolutions that work for everybody, and maybe that's not always possible.
I think we've been trying to do that for years, and we seem to be unsuccessful at it because of changing times, changing circumstances, changing nature of the business, changing neighbors, changing anything.
So for me, it would either be the course that I recommended earlier, or revocation based on illegality, and I just don't think I know enough yet to make that decision.
No, and I don't favor that decision, to be frank about it. I think we should do either your approach or find that we have no authority to grant this special permit, and the applicant needs the operator.
No, that's what I mean. I'm just not clear on that, whether that's necessarily required by the law.
a valid
Right,
analysis.
right.
Okay. Mrs. King, what do you have to say?
I have nothing new to add at this moment.
Okay. I think what Brian says is correct. I have made an assumption, it may be reasonable, but it also may be gratuitous, that Judge Sand's opinion, because it's a rather recent opinion, is based upon our current bylaw here. But I can't tell you I've read the record or read the briefs or anything like that. The complaint was filed in 2009, and it gets to Judge Sands with a decision in 2011. I think the conundrum, great.
I was going to say, does it make sense for us to
Please keep your.
briefly adjourn our deliberations and come back for another public meeting, but not hearing, in a week or so, and either I or John Flynn or somebody can try and look at that issue?
Look, I have no problem with that approach. The difficulty that I have is just a practical one.
I understand.
And that is, as of Wednesday afternoon, I'm gone. Okay? I'm available. But I was going to write this decision. I was going to write this decision tomorrow, as a matter of fact, because I have no other time to do it. So we can certainly do that, but we can't do it, I think, within the time constraints of August 29th. That's the reality of it. Now, you could write the decision. I could sign the decision, because I can get documents anywhere in the world to sign them and get them filed, but that's the issue.
Well, let me ask Mr. Dunn. Mr. Dunn, given this colloquy amongst us tonight, would you be inclined to give us a little bit of additional time to think about this?
Absolutely.
Okay, then what's convenient for you in your schedule?
I mean, we could do it on Tuesday if you want, if you're gonna leave on Wednesday, no?
I didn't hear that.
We could do it on Tuesday if that were okay, but Mr. Leonard says that doesn't work for him.
Mr. Dunn, are you around in early September?
Yes.
Do you have your schedule with you there?
No, but it's pretty open.
Okay, I'm shocked. No lawyer should admit to that.
At night.
Just at night.
Well, at night.
No,
Well, let's see what we have here. Let me ask you this. I know Mr. Johanning wants this thing on and over with. If we could, you available on the 17th?
Of September?
Yes.
Yes, at night?
Yes, how about you, Jenny?
Is that a Tuesday?
Tuesday.
Yes, I believe so.
Can we do this? Can we go over to the 17th of September for a very brief hearing?
Meeting.
Meeting, excuse me, meeting. I stand corrected by Mr. Hurley. Whoops. Okay.
There is
No,
just
no, I got- The 17th for a hearing, and we'll agree that a decision will be filed on or before the 27th. That'll give me plenty of time to write the decision. That make sense, Mr. Dunn? That agreeable to you?
Can you just give me the date one more time?
Yeah, the 17th at 7:30 for a brief meeting, so we can come to a conclusion on Judge Sand's opinion. And then the 27th for the decision to be filed. How's that with you, Mr. Delona?
I'm not necessary for your deliberation.
I'm sorry,
I am not necessary for your deliberation.
thank you.
Timeline will be fine.
Okay.
So we'll meet to further deliberate and then vote.
Yeah, we'll meet to further deliberate on the 17th at 7:30 to discuss this and vote, and then we'll have a decision rendered on or before the 27th of September. And I could also suggest, you tell me if, I don't think this is procedurally improper, but if either council wanted to write anything regarding the applicability of Judge Sand's decision, do you want to receive that, or is that?
Not only is it okay, I would welcome it.
So, if any of the lawyers before the 17th want to file an additional memo as to whether Judge Sand's decision in the Leiden versus Board of Appeals matter is applicable to this case, would be delighted to receive your comments and your memos. Okay? Not, and if you file nothing, there's no adverse inferences drawn one way or the other. Then we'll just decide it on our own. So, everyone in agreement with that?
I'm
Right.
agreeing.
Okay, so I say this, thank you very much for your attendance, and we'll see you on the 17th at 7:30. Thanks, and we're adjourned.